How y'all?
Yeah, I was see today. I'm not sure.
Who was that?
Yeah, it would either be, yeah, Chris and the other guy. What's his name? Jake? Josh or Jake? Yeah.
Let me enter the meeting.
So what do you normally do when you get them? So it's unusual.
It's 20 here.
Are you checking people in yet?
How's everybody this afternoon?
How you doing?
All right, how are you?
Good afternoon, how are you?
Lovely, Judge.
Sorry that we
Absolutely.
got on a little late
Yeah.
due to lack of technical resources, but we are here now. Howdy, howdy, howdy.
What's up, Judge?
Everything's well, Mr. Culpepper. All right, let me see. Who do I need? I need Melita Barrett first.
Okay, I'm here.
Okay, and we need Mr. Lee. Is Mr. Lee in our custody? Where is Mr. Lee?
We got Mr. Lee right.
Okay, great. Let us first call people of the state of Michigan versus Tony Romando Lee. This is case 20-5452. Your appearance is for the record, please.
Good afternoon, Your Honor. I was here on behalf of the people, 1044.
Just a second. Let me. Always on. Mr. Tuttle, would you mute
Yes, Your Honor.
yourself, please?
I didn't hear you.
Would you mute yourself, please?
Absolutely. Sorry about that. I was walking to my house. So
No problem. All right. Have you
Good afternoon.
Go ahead, Ms. Barrett.
Good afternoon. Melita Baird on behalf of Tony Lee.
Okay. We all prepared for sentencing today?
Yes, Judge.
Okay. So, Ms. Barrett, have you had an opportunity to review the pre-sentence report for its accuracy and for its inclusiveness?
Yes, Judge. We don't have any additions or deletions.
Okay. And how about the sentencing information report? Does that appear to be accurate?
Yes, Judge.
Great. Anything that you wish to say, Mr. Konohachi, before I give the defense and Mr. Lee an opportunity to speak? Anything?
We just ask that you follow the sentence agreement and the guidelines, I believe, are accurately scored.
Okay. Anything you wish to say on behalf of your client, ma'am?
Just, Judge, that he wants to rehabilitate himself and get back to his life as soon as possible.
Amen. And Mr. Lee, have you had a chance to go over it? And is there anything that you would like to say today before I impose sentencing?
No.
Okay. The agreement was 15 to 30 years in the state prison for Southern Michigan. So that is what the sentence of the court. He'll be given credit for 432 days that he has been in jail waiting to have this situation resolved. Mr. Lee, you don't have an absolute right to appeal your sentence and your conviction. You can appeal by leave if you wish. If you wish to appeal and can't afford a lawyer, one will be provided to you at no expense to you. Fill out the forms and return them once you get them within 21 days from today's date. And you will be given a lawyer to perfect your appeal. Questions?
Nothing further on behalf of the people. Thank you, Your Honor.
Thank you.
Thank you. Have a good weekend.
Thank you.
Bye-bye.
Good luck, Mr. Lee.
Thank you.
All right. Thank you, sir. Let us see who else is in the jail that we have. And in the meantime, can we do Kenneth Parker? Are we ready on the Parker matter?
Judge, how are you?
I'm good, thank you. And yourself?
I'm fine. Can we have Miss Tracy Anderson, the iPhone, and anybody else who's not participating in a case put themselves on mute, please?
And Mr. iPhone, put your name where your iPhone is. Huh. I like that one.
Ms. Anderson, can you find a way to mute your device as well?
Yes.
Take care of them, Jaquetta. Do your thing. Who do we have in Division 2? Young man, what is your name?
Trayvon Malone.
Mr. Malone. Are we ready on the Malone case?
Yes.
This is case number 21-1287-24504. This is Trayvon Martez Malone. Your appearances, please.
Good afternoon, Your Honor. Steve Lockbiller for the people.
Steve Teratuta for the people on the 24504 case.
Good afternoon, Your Honor, and for Delisha Coleman, P56278 on behalf of Trayvon Malone on the case with Mr. Teratuta. Will stand in for attorney Frances Murphy as she's here today. We were basically coming back in regards to my request for an investigator. And I did reach out to Miss Angela Peterson. She said I needed to get from the court an order for an investigator, and we will be on and flying.
Okay. And so you're able to do that without any difficulty, is that correct? Send a messenger.
Messenger?
Pony Express.
Oh, okay. I'll choose the email option.
Then I'll sign it and I'll send the email back. In the meantime, let us schedule a final conference date so that you can get all of that information together and we can move on. Mr. Teratuta, as it relates to that case, it is, I see, a murder in the second degree. Is there a sentence agreement or an offer that you would like to place on the record at this time?
Your Honor, we placed an offer on the record last time and it was rejected. I asked Ms. Coleman Taylor to speak with Ms. Towns if that offer will be tweaked at all, and I have not heard from her or Ms. Towns in regards to any further offers.
Okay. Can we?
I can speak with Ms. Towns again.
Right.
Last time I spoke with her, that was the offer that was had, but since we've changed prosecutors to Mr. Teratuta, maybe there's some additional information. I don't know.
All right. Well,
but I would ask to get the information from the investigator and then talk to her.
Okay. Well, let's hope that the investigator will have completed that investigation and provided you with what you need. We'll schedule the final conference for the 1st of October on docket C. Righty.
Sounds good.
Thank you, Your Honor. And I
right.
will be seeing you, Mr. Malone. I'll be Zooming in with you as soon as possible.
Young man in on floor in the jail. What is your name, sir? I see the deputies helping you. Okay.
Ted Anderson.
Okay, are we ready on the Anderson case? Is Mr. Mark Brown on? Mr. Mark Brown, let me see if I can find him. I cannot see Mr. Brown. All right, Mr. Anderson, just hold tight. When Mr. Brown comes on, we will help you.
Your Honor, Your Honor, we have also, we have Ted Anderson, Johnny Espino, Marlon Crawford, Brandon Mullins, Thomas Hosiet, and Rico Lopez, and Ashley Sanders, all here.
Hold it. You're going too fast on me.
Sorry.
You have Rico, Mullins, Espino, who else?
We have Rico Lopez.
Right, okay, I got you.
Thomas Hosiet.
Okay, I got you.
Brandon Mullins.
Got Mullins.
Marlon Crawford.
Oh, Mr. Crawford, there you go, okay.
Johnny Espino.
Yes, got that.
Ted Anderson,
Got that also.
and Ashley Sanders.
Got you. Thank you. You
You're
have
welcome.
done me fine.
Judge, at Division 2, there's Kenneth Parker,
Okay.
Michael Taylor,
Okay.
Michael Stokes,
Okay.
and Christian Stone.
Christian Stone, got you covered.
And we're all ready, Judge.
I appreciate that. Who is in the chair right now?
This is Kenneth Parker.
Okay, thank you. Mr. Gonick, are you ready on Mr. Parker, sir?
Yes, sir.
Okay, thank you. This is case number 21-1971, Kenneth Parker. Your appearances for the record, please.
Good morning, Your Honor, or good afternoon, Your Honor. Brittany Johnson on behalf of the people, P83513. I'm standing in for prosecutor of record, Ms. Danielle Seamus.
Good afternoon, Your Honor. Ben Gonick appearing on behalf of Mr. Parker. My bar number is P43716, and we consent to these proceedings being accommodated by Zoom.
Thank you, sir. I understand that Mr. Parker wants to enter a plea of guilty. Is that correct?
That is correct, Your Honor.
Okay, Mr. Parker, may I ask you to identify yourself and to promise that your answers to my questions will be truthful?
Yes, sir.
Okay. And how old are you, sir?
41.
Mr. Parker, is it your desire today to enter a plea of guilty?
Yes, sir.
Has anybody forced you or threatened you to get you to plead guilty?
No, sir. I have a question, Judge.
Well, we're about to get to that part.
Okay.
You want to jump ahead. Go ahead, Mr. Parker. That's all right, Mr. Parker. Jump ahead.
I wanted to know if the time that I've done in the county, will it be credited to my time, to my plea?
As long as you are not on parole, the answer is yes. Are you on parole?
No, sir.
Okay, well then the answer is yes to your question.
Okay.
And I'm sure your lawyer told you that though, didn't he?
No, sir.
Yes, he did. You just wanted to check to see if your lawyer was telling you the truth. Mr. Gonick told you the truth. Anytime that you're in jail gets counted towards the minimum of your sentence. And so
Okay.
I understand that there is two things happening in your case. There's a charge dismissal and there's a sentence agreement. You're going to plead guilty to 2 counts. One is felon in possession of a firearm. That carries up to 5 years in prison, from probation to 5 years. The second one is a felony firearm second offense, which carries a mandatory 5 years. And they're going to dismiss counts 1 through 6. Is that your understanding of what's going to be? And for the felon in possession, you're agreeing to a sentence of 1 to 5 years in the state prison for Southern Michigan, and the other is a mandatory, like I said, 5 years, and they will run consecutive to each other. So is that your understanding of what's happening?
Yes, sir.
Any other secret deals out there that somebody told you not to mention, Mr. Parker?
No, sir.
Okay. Are you pleading guilty because you are guilty?
Yes, sir.
And again, nobody's forced you or threatened you to make you plead guilty. Is that correct?
Yes, sir.
Are you pleading guilty because you want to?
Yes.
Okay, by entering a plea of guilty, you're giving up your right to go to trial, Mr. Parker. At trial, you would have an absolute right to confront any of the witnesses that came into court to testify against you. If you wanted to at trial, you could defend yourself by calling witnesses, by producing diagrams and exhibits into evidence, or being a witness in your own behalf. You wouldn't have to because you're presumed to be innocent, and any statement, and any verdict that was reached as a result of the trial, you could automatically appeal. By entering a plea of guilty, you're giving up your automatic right to appeal, and you can only appeal by leave. Do you have any questions as to any of the rights that you have, Mr. Parker?
The time that I've done in here, will that go towards the minimum on the first case or second case?
It will go towards the first case. I'm
Okay,
sorry, no, it goes towards the felony firearm.
all right.
All right, so do you remember the date, September 31st of last year in Van Buren Township?
Yes, sir.
Did you have an encounter with the police?
Yes, sir.
And how did that encounter turn out? Did you get arrested?
Yeah, no, I got arrested. No, I didn't get arrested. I went to the hospital.
Okay, well, when did you have when did you meet up with the police?
At the hospital.
Okay, and when you were at the hospital, did they take a gun off of you?
They got the gun out the trash can.
And who put it in the trash can, Mr. Parker?
I did.
Okay. And did you have a prior felony conviction when you possessed that weapon, Mr. Parker?
Yes, sir.
Okay. Are both sides satisfied with the factual basis and have complied with the court rule and the taking of the plea?
I am,
Yes, sir.
Your Honor.
People are.
Okay. We can do sentencing the 16th or the 24th of September. What's your pleasure?
16.
Okay, that'll be on docket C. Are you available on the 16th, Mr. Gonick?
I am, sir.
Okay. And that would be on docket C.
Okay. Thank
Mr.
you.
Parker, you seem to be a happy man. You want to share some of that glee with me?
I'm good. I'm happy with everything that went on in the court today.
Okay. Do you have any more questions before we say goodbye to you?
No, sir.
Okay, I'll see you in September then, sir.
Yeah, I'll see you too.
All right, thank you.
Thank you.
Thank you.
Thank you, Your Honor. Have a good day.
I appreciate everyone's help. Mr. Savage, are we ready on your client, sir? I told you we would be first. I'm not going to keep it on board forever this afternoon. Mr.
Yes, Your
Andrew,
Honor.
I know you're around. I saw you when I let everybody in. So this is the problem. This is 21-00066, Luis Miguel Andre. Your appearances, please, for the record.
Good afternoon, Your Honor. Steve Lockbeeler for the people.
Good afternoon, Your Honor. May it please the court. My name is Matt Savage and I represent Luis Andrade. Your Honor, I know you've been more than gracious with us on this case. It's taken some time to get to the point where it's at now. Unfortunately, I have to respectfully ask the court for one last adjournment. I'm 90% sure this case is going to be pled out on the offer that's been made. However, Mr. Lockbeeler has been kind enough to give me his calculation of the sentencing guidelines, and they are night and day compared to my calculation. So I need to obtain some additional information in regards to a couple of the offense variables, which would involve injuries. I have access on a civil case that's involved with my client and the complainant / victim in this case. So I'm hoping the attorney that's handling that will be able to get me some information. If not, maybe Mr. Lockbeeler can help out. So this way I can give Mr. Andrade a clear idea of what his sentencing guidelines will be before he pleads.
We can work that out. That's all right.
I really appreciate that.
Sometimes it's what's required, right?
Thank you, Judge.
No problem.
Yes.
So I can give you September the 8th, if you'd like, or September the 13th.
Well, 13 is my favorite number, so let's go with September the 13th.
Okay. September the 13th for Mr. Andrade. All right. I wish everybody a good day.
Thank you, you too.
All
Thank you,
right.
Steve.
Thank you.
Bye, Your Honor.
Thank you.
Do I have Miss James with us?
Judge, the case you just called, I didn't have that on my docket. Can you please repeat the number, case number and name again?
It should be the third one down on your docket, 21-0066. Luis Miguel Andrade.
Hello.
Thank you.
No problem at all. Always love to help out.
I don't know how I missed it.
Well, that's all right. Sometimes they say if it had teeth, it would bite you, right? And that's sometimes how they say. So just don't even sweat. Mr. Brown, what case are you on with us today?
I'm with Mr. Ted Anderson. Ms. Cox, I saw her, I spoke to her earlier, so I think she's here unless she had to go back to Mr.
Right. You know what? I've got to do better with my calling of my names, because we called Mr. Anderson and you had yet to come back in. And so let me see. I don't see Ms. Cox on yet. Or maybe I have missed her. We have quite a few people on. So that's easy to do.
Mr. Tuttle, do you mind putting your device on mute? We can hear everything you're doing out there.
Mr. Dwayne Brown, what case are you on today, sir?
Good afternoon.
Likewise.
I have Mrs. Ashley Sanders.
Okay. Are we ready on the Ashley Sanders matter? I have it listed as the lawyer was Nancy or is Nancy Blount.
Judge, it would be listed as me, Mark Magidson. Nancy Blunt, as I understand it, has been a judge over at 36th District. I've been on the case for the entire time. We did a preliminary exam the other day.
Well, that's wonderful. So now that we got you, this is case number 215505. Is Miss Ashley Sanders in or out of custody?
She is in custody.
Okay.
Although I'd like to address that maybe.
Well, not without the young lady here and not without a transcript.
She's in the chair.
Oh, okay. I see you. Ashley, tell us good morning. Good afternoon, please, Miss Sanders.
Good afternoon, Judge.
All right. You don't mind us doing this Zoom court this afternoon, do you?
No, sir.
Okay. This is case number 215505. Your appearances for the record, please.
For this record, Dwayne Brown appearing on behalf of the people.
And Mark Magidson appearing on behalf of Ashley Sanders.
Okay, it's scheduled for an arraignment on the information. What is your pleasure?
Waive the formal reading of that information. Stand mute, ask that a plea of not guilty be entered.
It will, sir, and it will. This is a Thomas Hathaway case. Is that correct, Mark Ulatowski?
That's right.
Okay, we'll ask Mark Ulatowski, Mark Magidson, to give us a date. That's all. And to order the transcript and whatever else you might need.
The transcripts should be due by September the 16th, and we could put this on September the 2nd, which is a Thursday, and that would be the C docket with Judge Hathaway.
Judge, can we order a pretrial services report for what it's worth?
Consider it done. Sure, Mr. Ulatowski, from your ears to his hands. I mean, from your mouth to his hands.
Can't ask for anything more.
There might be one, Judge, because it's already been ordered. It was ordered on the 16th of August, so.
Maybe we already been there and done that.
Yeah.
Well, this is the arraignment on the information, so I don't know how you can have been there and done that, but we'll make sure that it gets to Thomas Hathaway.
Yeah, I've got it right here, Judge.
Oh, okay.
Perfect.
All right. Thank you much. Good luck to everybody.
I'm on Mullins too, whenever the court gets a chance.
Well, since I got you, why don't we do Mullins? If
you know what, I would like, this is a sentencing, and I got the pre-sentence report yesterday, and I have not been able to go over it with him. Is there a way I can get into a breakout?
If we have when we get Mr. Mullins.
Yeah, he was listed in Division 1.
I do not have the pre-sentence report. If the court can email it to me, I can review it. Otherwise, you may need another date.
I can probably email it to you. Mr. Mullins is on parole hold, so he's not getting credit for these days.
Okay, so you're going to email it to Mr. Lockbiller? That's wonderful.
Right, so I can, if he can put his email in the chat, that would be great.
Yep.
Ms. James, are you with me this afternoon?
Yes, Your Honor.
Okay, are we ready to do your man, Mr. Bryce Adams Sis?
Yes, Your Honor.
Okay. This is people of the state of Michigan versus Bryce Isaiah Adams Stiff. This is 21-1125. Your appearances for the record, please.
Good afternoon, Your Honor. Joshua Holman on behalf of the people, P number 71971.
And good afternoon, Your Honor. Nicole James, appearing on behalf of Bryce Adams Stiff.
All right. Is it conclusion day today?
I don't think so yet, Your Honor. I've just been speaking with Ms. James a bit since our last court date. I think there's been some breakthrough in the negotiations, but we need just a little bit longer to try and finalize some things. So if the court is willing to grant us a few more weeks to try and work some things out, I think that could be fruitful for both parties.
How can I resist 2 lawyers against 1 judge for what makes sense? All we need to do is pick a date now. So we have September the 8th or the 16th available, or the 24th. So tell me what you like.
My guess is that we'll probably need more time than September the 8th. What were the later dates that the court had?
We can do September the 24th, October the 1st.
I'm available each of those days. And I think that would give us enough time.
All right, Miss.
Judge, I was asked the court for October 1st. I'm supposed to be in a jury trial that September date.
Okay, that's going to be on docket C.
That's fine with the people, Your Honor. At 1 o'clock then?
Yes, sir. 1 o'clock.
Thank you, Your Honor.
Thank you. I'll see you later, Mr. Stiff. It'll be in October. You'll have a good 6 weeks. See you then.
Thank you.
Have a good one, everyone.
All righty. So who do we have in Division 2, young man?
On my camera, Judge, we have Michael Stokes, and on the other Division 2 camera, we have Michael Taylor.
Okay, Stokes and Taylor. Mr. Kinney, you're on Michael Taylor, is that correct?
Yes, sir.
Okay, well, let's call yours. This is 21-44-22. Michael Andre Taylor. Your appearances for the record, please.
Good afternoon, Your Honor. Emily Annal, P80553 for the people.
Good afternoon, Judge. Robert Kinney appearing on behalf of Mr. Taylor. Miss Annal gave me an offer, but I wasn't able to get into the jail to talk to Mr. Taylor about it. Can we get some time to talk to him?
Yes, we can. The next time when the docket is shortish, and I mean short, is September the 8th.
Thank you, Judge.
All right, we will see everybody back on Michael Andre Taylor on September the 8th.
Mr. Kenny can do my case too while he's there.
What is the offer as to put on the record for Mr. Taylor?
Yes, Judge, the offer is for Mr. Taylor to plead guilty to count 1, criminal sexual contact in the 3rd degree, person 13 to 15, which is a tier 3 offense under SORA, with a sentence agreement of 10 to 15 years in the Michigan Department of Corrections, compliance with Sex Offender Registration Act, which would include lifetime electronic monitoring, no contact with the victim in this case, and sex offender treatment. In exchange, the people would agree to dismiss counts 2, 3, and 4, as well as the habitual offender 4th offense notice provision.
Thank you, Mr. Annell.
You're welcome, Judge.
Back in about 3 weeks.
Yes, Judge. Thank you. And
This is
Judge,
yes.
oh, I'm sorry. Just before you continue, I have a case with Mr. Holmberg. He had asked, we were wondering if you could slide us onto the docket somewhere if you had time. He had a bond request, and I said I would have no objection to putting it on the record if the court would allow us, but.
Okay, since you twisted my arm.
Gebner, can you come here?
And what is the name of the case, please?
The case is People v. John Gebner,
Sorry.
Your Honor. And it's 2100165201FH.
1652.
Yeah.
Okay, thank you for calling the case. Would the parties place their names on the record, please?
Good.
Judge, can you call the case again? I just was writing it down because I didn't have it on my docket.
Spell Mr. Gepner's last name, Ms. Hamill.
G as in George, E as in elephant, B as in boy, N as in Nancy, A as in alpha, R as in Roger. First name John, common spelling.
And that's 211652.
I'm at 211652, People versus John Gibner.
Okay, Jack, thank you, Jack Ryder. All right, your name's on the record one more time, please, Mr. Holberg.
Good afternoon,
Yes, Your Honor.
Honor.
Edward Hol.
Oh,
sorry.
Emily Annell, P80553 for the people.
And Edward Holmberg, P62763 for the defendant. And Mr. Gebner is right there, Your Honor.
So hello, sir, please.
Hello, Your Honor.
You doing all right?
Yes, sir.
Okay, well. All right, what would you all like to say as it relates to bond, please?
If I may, Your Honor, my client's sister is terminally ill. She's in hospice. Her name is Vicky King. She's at the 39448 Village Run in Northville. She was admitted to hospice. I guess she's got terminal lung cancer. He would like the opportunity on Saturday to see her and hopefully say goodbye, and not to be rude, but I guess that's where we're at with this. So he's asking for basically a release for 4 to 5 hours out of house arrest to go spend some time with her at a hospice.
And the people's position?
Judge, I have no objection provided that there are no minor children present during his visit, given that he's charged with criminal sexual conduct.
And we have no objection to that, obviously. So
okay. So have you all agreed on a bond amount and the condition tether?
Right. He's on tether, Your Honor. He is on tether presently, and he's out on bond, and he's got a tether on. His district court judge had put him on house arrest, where he could only go to doctor's appointments or my office or court. And prior to that, it was no court because it was during the COVID.
No
that
problem.
being said,
no problem. I understand. I'll change the restriction for Saturday to allow him the whole day just to be on GPS to decide when, and for house arrest to resume on Sunday.
Thank you so much, Your Honor. Appreciate it. You have a nice day.
Thank you.
Thank you, Your
And
Honor.
thank you, Judge, for accommodating us and
No
everyone else.
problem.
I do appreciate it, Your Honor. Thank you, Emily.
Way to push to the front. Okay. This is Fred Dixon Jr. Are we ready on Fred Dixon Jr.?
Yes, we are.
Okay, where is Mr. Fred Dixon Jr.?
Good afternoon, Your Honor.
Thank you, Mr. Dixon. Now I can see you. This is case number 203201. Your appearances for the record, please.
Good afternoon, Your Honor. Steve Lockbeeler for the people.
W. Otis Culpepper for Mr. Fred Dixon Jr.
Okay, what are we going to do with Mr. Fred Dixon Jr., Mr. Culpepper?
The government has made an offer and we are going to accept it. Mr. Dixon understands this is going to be done virtually. We do have, Mr. Lockbiller and I talked about something. He sent me a copy of the plea agreement. My secretary do pandemic, and I am not skilled enough to do that virtual sending of things. So we are in agreement that if the court or the court's clerk could sign Mr. Dixon and my name to the document.
We will, with permission given by yourself, and act with the authority that you have vested us with. We will sign that thing.
I'm having technical difficulty. Can you hear me?
You're breaking up a lot, Mr. Culpepper.
You're kind of frozen. So are you, Your Honor.
Well, that's common for me to be breaking up.
Well, I heard everything that everybody else did until it was my turn.
Yeah, so likewise, I was clear as a bell until we called Mr. Fred Dick. Maybe it's Mr. Dixon's fault.
It's Robert Kenny. He should have took me.
Ah, you're right. It's Mr. Kenny's fault. Anyway, Mr. Dixon, do you promise to tell me the truth today, sir?
Yes, sir.
It says here that you want to plead guilty to a reduced charge of attempt carrying a concealed weapon, which carries from probation up to 2.5 years in prison. Is that what you would like to do?
Yes, sir.
Is anybody forcing you to plead guilty?
No, sir.
Anybody threatened you to get you to plead guilty?
No, sir.
Whose ideal is it to plead guilty? Oh,
It's
yeah,
my
Mr.
idea.
Kenny's. Yeah. Do you understand by entering a plea of guilty, you're giving up your right to be presumed innocent as well as your right to go to trial? At trial,
Yes.
you can confront any of the witnesses that would be brought into court to testify against you. Likewise, if you chose to present a defense, you could by calling witnesses, having diagrams or exhibits entered into evidence. You could testify in your own behalf if you chose to. And of course, you could choose to do nothing, which is appropriate because the presumption is with you and the prosecution has to overcome that presumption by a standard called beyond a reasonable doubt. If you were found guilty by trial, you could automatically appeal the verdict and whatever sentence was imposed, but by entering a plea of guilty today, you're giving up that automatic right to appeal your sentence and your conviction. Do you have any questions, young man?
No, sir.
Do you remember the date of March the 5th of last year at Connors on the east side, Edsel Ford Service Drive?
Yes, sir.
What brought you to the attention of the police, Mr. Dixon?
I was driving down Harbor Avenue towards Connor. I was probably doing a little bit over the speed limit.
Oh, okay.
I got stopped.
And when you got stopped, what went down, sir?
The officer asked me, did I have my license on me? Which I didn't have my license on my person at the time. The officer asked me to step out the vehicle. When he asked me to step out the vehicle, I had a firearm in my pants.
Okay. Both sides satisfied with the factual basis and that I've complied with the court rule in the taking of this plea?
People are satisfied. Oh.
We can't hear you, Mr. Culpepper. I'm sorry.
I'm sorry, and you were frozen. Satisfied.
Okay. We can do sentencing September the 20th, if you'd like. Is that a good date, September the 20th?
It has to be on a Monday?
No, we can do it September the 16th or September the 24th.
1 second. All right, the 24th, Your Honor.
Okay, and that's going to be on docket B at 9 in the morning.
What was that? September 24th.
Yes, on docket B.
Yeah.
Mr. Dixon, I need you to call this number today, sir.
Yes, sir.
313-456-4600.
Yes, sir.
And let them know that you want to be scheduled for a pre-sentence interview, okay?
Okay.
All right, you have any questions?
No, sir.
What are you doing this weekend?
Hi, is this Mr. Lewis?
Sitting around.
Sitting around.
Magazine.
Sitting around.
Well, how are you?
Did you
Helping
know
mom and dad clean up their house.
take them downtown to the Charles H. Wright Museum this weekend?
That sounds like a plan.
Right, there's a little, the African World Fair where there's a lot
Yeah.
of vendors and food and some music, and it's all free. You get a chance to get that dashiki out of the closet and throw it on.
Like the one you got on.
Thank you, Your Honor.
Hold it. You know I'm ready. You know who's leaving right after work.
Yes.
Got my shirt on, got my little bangles on. You know I'm ready. I'm going right downtown. Just stay
That's
right
why we,
here.
that's why we love you, baby.
Going to pick up a couple new shirts.
That's right.
All right. Have a good week.
You have a blessed weekend.
Thank you. You do the same. Are we ready on Mr. Oh, let me get a jailer or two now. Young man on division, who's on the 8th floor? What is your name, sir? Let's get a couple jailers going.
We have Mr. Mullins right here on this computer, and on the other computer on the 8th floor, and it's Mr. Crawford.
Okay, let's keep Mr. Mullins because Mr. Magidson is going to be with us in a second as soon as he gets off the phone and unmutes himself.
Okay.
Mr. Magidson, I need your attention. I can't deal with a divided man. You guys in the chair? Do people realize that the camera is watching them? I mean, I want to help Mr. Magidson get whatever's in his eye out of his eye for him. Mark Magidson, are you with me? You must have me turned off and yourself turned off. Mr. Mullins, in the meantime, you doing all right, sir?
Hang on a second. Judge, I'm here.
Okay, now you're here. Okay, this is your client, Mr. Mullins. This is Brandon Mullins on 21-3153. Are we ready for sentencing today, sir?
Judge, I do have I provided Mr. Lockbeer with a pre-sentence report. I have the pre-sentence report, but I have not had a chance to go over everything with Mr. Mullins in terms of the pre-sentence report. However, we do have a sentence agreement.
Okay, so would you like to be put in a breakout room with Mr. Mullins?
I see him nodding his head.
Okay, well, I'm going to do that. Manually assign manually. Okay.
The way I got you to call the case is I got on another phone call, and that always happens.
Whenever I see that there's competition, I get jealous. Okay, let me put Mr. Mullins and yourself, and away you go.
Thank you, Judge.
Your Honor, we also have Mr. Marlon Crawford in front of this computer in Division 1, 8th floor as well.
Okay, and I see his lawyer. Let's call Mr. Crawford then. This is 21-0577, People of the State of Michigan versus Marlon Wayne Crawford. Your appearances for the record, please.
Good morning, Your Honor. Steve Lockbeer for the people.
Good morning, Your Honor. Jabari Prempeh, P81745, on behalf of Mr. Marlon Crawford, present from the jail via Zoom.
Mr. Prempeh, you know, usually we keep newer people to the very end. Man, you better be happy they
I've
put the
noticed.
client.
I've noticed this hazing, dog. I mean, I've noticed this. This is awful.
It's
But it,
about that, man. It's about you have to learn lawyers you never met before. You have to hear clients do their thing. This way you get the benefit of knowledge for
yes,
free.
sir. Yes,
But,
sir. Yes, sir.
But it looks like musical chairs has your client there. So,
Hey, but wait a minute. Where'd he go? He was sitting there.
He sure
right,
was.
It's right here in front of the straight man.
Okay. Oh, they playing. Okay, I see the musical chairs. I see what you're saying.
That's exactly. So thank you for accepting that appointment. What do you need in terms of time or resources to better prepare you?
Thank you, Judge. I did have an opportunity to go see Mr. Crawford a couple of days ago. I do need copies of discovery. I have at least requested it by email to Mr. Lockbiller. Sorry if I'm messing up your name. And he has given me a plea offer. But I do need copies of discovery, and I have requested a copy of the preliminary examination transcript. I haven't received anything yet, so I am going to need some time to receive that information, review it, and speak with my client.
Let me make sure. Mark, the preliminary examination transcript is ready to be downloaded by Mr. Prompe, correct?
What case is this? I'm sorry.
No, it's all right. It's Mr. Crawford. It's case number 210577.
Give me.
Take your time. Take your time, please. Don't even worry about it.
Judge, you messed up. You let me in on that secret, man. I thought that's what was going on because I've been spending just hours hanging on, waiting for the judge to call me. I see the game.
Yeah, well, it works it works amazingly so sometimes to your benefit, because I'm a firm believer sometimes that what man means for bad, God means for good. So, in the end, like we say, somebody got to be last, might as well be you.
Judge,
It is so awful there.
Yes, Mark.
Yeah, I'm showing the transcripts were filed back in April.
Okay.
5th.
So, Mr. Prompe, you're able to just go online and download the transcripts.
Okay.
And Mr. Lockbiller will, if you put your email in the chat, I'm sure Mr. Lockbiller will make sure that you get the discovery.
Yes, we already are communicating by email.
Okay.
I'm certain it's on its way.
Okay, excellent.
Actually, trying to do it right now.
Would you like to come back on September the 8th or 16th?
Let's make it the 16th, Your Honor.
Okay, Mr. Prompe, that's good. And okay, so since we're talking about things, as it relates to me, I like my name being used. I don't like the honorable. That, use that for when you really know me.
Fair enough. Fair
And
enough.
then
Thank you.
Call me my man, Judge Morrow.
I appreciate it, Judge.
That honorable thing, it elevates those that aren't worthy of elevation, if you know what I mean.
Well understood.
All right.
Thank you, and I'll see you on the 16th.
No problem. Mr. Crawford, you doing all right?
Sir. Yes, Judge.
Well, and Mr. Prompe, he's being a nice lawyer, giving you the attention that you want.
Yes, sir.
Okay, well then I'm satisfied, because you at least you're quiet this time, so he must be doing his job.
Yes, sir.
Okay, I'll see you next month, sir.
Yeah.
Take care.
Thank you. All right. Right. In Division 2, what is your name? Are you our other person?
We got Michael Stokes here, Judge, and in the other Division 2 camera, we have Christian Stone.
Okay, we have Wyatt Harris on. Mr. Harris. Wyatt Harris. Who has both of those people? I don't see Mr. Harris on. Yep, I see him on. Mr. Harris. Mr. Harris, come in, Mr. Harris, wherever you are. You're with me today. Where are you, Mr. Harris? Attorney Wyatt Harris, 54891. Calling Mr. Harris. Calling Mr. Harris. All right. Mr. Kinney, is Mr. Hill out on bond or is he in custody?
He's in custody, Judge. He was in Division 2, but I believe
Right, 'cause I
that,
didn't hear them call his name.
yeah, I believe they sent him back. He was on parole.
Oh, that's not good.
No.
Okay. Well, let me give Mr. Tuttle's, because I see his client is out, and we'll try to get Mr. Oh, there's Mr. Harris. Good afternoon, Mr. Harris.
Afternoon, Your Honor.
You doing all right today, sir?
Doing fine. How are you?
Well, you don't sound very energetic. I'm energetic, man. I'm doing really good. We have Mr. Stokes and Mr. Stone, whichever you'd like to. Are you prepared to do Mr. Stokes?
I am, Your Honor.
Okay, and Mr. Stone?
I'm prepared to do both.
Okay, let's do the sentencing for Mr. Stone first, if we might.
I don't think he's been sentenced, Your Honor. He hasn't pled to anything.
Oh, I'm sorry. That's Mr. Sharp, and I got the wrong guy. But Mr. Sharp is supposed to be on today. Michael Phillips Sharp, wasn't it adjourned to 8:20? And that is today.
It could have been, Your Honor, and I don't know if Mr. Sharp is on now. Yeah, boy.
Okay, well, let's deal with what we have. People of the state of Michigan versus Christian Stone. This is 21-2514. Mr. Stone, please say good morning, good afternoon to us.
How you doing, Judge?
I'm doing all right. Thank you, Mr. Stone. And who's representing the state of Michigan?
Good afternoon, Your Honor. Steve Lockbill for the people.
All right, I have this as a calendar conference for Mr. Stone. Has there been an offer that's been conveyed to defense counsel today? Or before today?
There has not been. There's no reduced offer on this.
Okay.
Your Honor, Mr. Stone has a second case out of Inkster, and it's a capital matter.
Okay, and what posture is that in right now?
I think it's still at the preliminary exam stage. I am not representing him. Joseph Humphrey is, and so I'm not sure where it's at. It's a multiple defendant matter.
Okay. So you are saying what works in your client's best interest is just to have this one do whatever it's going to do out in space while the more serious one proceeds through the court system. So why don't we just set a pretrial date on this case, another pretrial date for 10/1, and then we might know a little more about the other case that Mr. Stone has.
That would be fine, Your Honor.
Mr. Stone, you kind of heard what we're going to do. We're just going to adjourn this out. We're not going to try to resolve this case, just set it out so that case that's coming up can fully develop. And since it's more important, you can devote your energies to trying to resolve that in a favorable way for yourself or for whatever works. But that's what we're going to do with that one. So we're not going to do a whole lot on this case. It just put it in a waiting posture.
Thank you, Your Honor.
Okay. All right. Thank you so much.
What docket would that be, Your Honor? What docket would that be on October 1st?
Thank you, Mr. Harris, on docket C. And if we could do Michael Leon Stokes.
Auto G Play, could you please mute yourself? Thank you.
This is APA King. I'm ready on the Stokes file whenever the court is ready.
Okay, Mr. Stokes was supposed to be.
Mr. Stokes is on the screen, Your Honor, Division
Thank you.
2, Annex Floor 7.
I see him now. Thank you. This is Michael Leon Stokes, 212832. Your appearances, please.
Well, good afternoon, Judge. APA Larry King for the people, P78774.
Good afternoon, Your Honor. Wyatt Harris on behalf of Mr. Michael Stokes, who appears from the Wayne County Jail with the court's permission.
Yes, thank you. Tell us good afternoon, please, Mr. Stokes, or at least acknowledge that you can hear us, please.
Good afternoon, Your Honor. I'm Michael Stokes.
Okay. So what posture are we in, Mr. King and Mr. Harris?
Your Honor, Mr. Stokes has filed a grievance against me for which I have answered and they have responded. I'm not sure what Mr. Stokes would like. If he wants to have me continue as his lawyer, if he wants to have someone else represent him.
Mr. Stokes, I'd like to hear from you, please.
Your Honor, I'd like to motion the court for evidentiary hearing, because I feel like I was misunderstood my attorney when he was telling me to waive my preliminary examination. And I just want a fair trial. I mean, if Mr. Harris is willing to go with me, then I'm willing to go. But I would like to motion the court for evidentiary hearing to see exactly what I'm charged with and the evidence that you have against me.
Okay, Mr. Stokes, I'm gonna do some guessing for right now, if that's all right, okay? I'm gonna guess that up to this point that you've had a chance to talk with Mr. Harris about what your case involves and.
No, sir. No, sir.
Mr. Harris, have you had an opportunity to talk with Mr. Stokes?
On several occasions, Your Honor.
Okay.
I have visited him in the jail. I have talked to him, not in the jail, but via Zoom while he's in the jail. I've talked to him the day of his rescheduled preliminary exam in person, talked to him about the particular facts of his case and risks that he faces with the charges. And Mr. Stokes made a decision based on that, on the preliminary exam day, based on that he would waive his exam. So I'm not understanding how Mr. Stokes doesn't understand what he's charged with and the reason why we waived his exam.
Mr. Stokes, Mr. Harris seems to think that you all have had some conversations and that you've been able to understand at least the positions that he's taken and the explanations that he's given you for those positions. That has that happened, sir?
No, sir, Your Honor. I think it's just been a breakdown in our communication. I mean, and now that Mr. Harris then said that, I'd just like to move on for another attorney if it's possible.
It is possible. Mark, we will ask assigned counsel to provide Mr. Stokes with a lawyer. Mr. Harris, we will thank you for your service and we will schedule this for 10/1. Mr. Stokes, somebody should be getting in contact with you, and Mr. King, that just puts this in hold, as you know, and I'm sure some other lawyer will get in touch with you saying that they now represent Mr. Stokes and ask for discovery, sir.
Very well, Your Honor. I'll wait to hear from somebody. Thank you.
Thank you. Thank you, Mr.
So,
Harris.
Your Honor,
Yes, Mr. Stokes.
as far as the evidentiary hearing, could you consider that?
Mr. Stokes, right now you don't have a lawyer.
Oh, okay. I understand.
Okay, so another lawyer will be appointed to represent you, and we'll go from there.
Yes, sir.
Thank you, sir.
Thank you.
All righty.
All right, Judge, that's all we have at Division 2. It's good seeing you as always. Have a good day.
I appreciate your help. Thank you so much.
Go back to Mr. Mullins, Judge.
Judge, this is Robert Kenny on behalf of Mr. Hill. If he's not in Division 2, he's not in the Wayne County Jail. Can we get another date? That means he's back in the Department of Corrections.
Okay, this is 213631 James Hill. Your appearance on the record, please.
Good afternoon, Your Honor. Steve Lockfield for the people.
Robert Kenny appearing on behalf of Mr. Hill, Judge.
And he is charged just with resisting and obstruction causing injury. Is that correct?
Yes, but he's a habitual, but yes.
I got you. We will track him down, and we can set this for the 8th of September if you would like.
Yes, sir.
Okay, and I will tell you in a hot second. And that will be on docket D.
Thank you, Judge.
Thank you. And Mr. Kinney, if you would just call to make sure, and we will call you to make sure. That way we'll just make sure that he's there. If it's easier, we can rid him back to the Wayne County Jail so that it's easier for you to reach out to him if you want to see him in person or
Yes.
set up a Zoom.
No, yes, I would prefer that he be ready back here.
Okay, that's what we'll try to do to make sure that he's here on that date, sir.
And is the transcript, can I get the exam transcript?
Let's ask Mark when it'll be ready, if it's ready now. Mr. Ulatowski, can you give us some insight, please?
They were ordered on July the 14th, so they should actually be due like any day now.
Do we have anything in the file, or they don't do that anymore?
No, they'll just pop up on Odyssey with a PDF to download them. And they don't give us like any notice, like here's your transcripts. You just have to look and see if they're there or not. If they're not there.
All right, please keep checking.
Thank you, Judge.
Thank you. Mr. Magidson, are we ready on Mr. Mullins?
We are ready, Judge.
Let me see if I can find Mr. Mullins again.
He's in the other chair of Division 1.
Okay, I see. Thank you. This is case number 21-3153. This is Mr. Brandon Mullins. Your appearances today, please.
Good afternoon, Your Honor. Steve Lockfield for the people.
Mark Magidson, Your Honor, on behalf of Mr. Mullins.
And Mr. Mullins, give us a shout out. Tell us you can hear us, please. All right. Thank you, Mr. Mullins. Go ahead, Mr. Magidson, please.
Judge, we've had a chance to go over the pre-sentence report with Mr. Mullins. Everything seems to be factually correct. No additions, subtractions, or additions, so forth. So we do have a sentence agreement here. 2 years probation with the first 10 months in the Wayne County Jail, 80 hours of community service, restitution, if any, although I do know from the pre-sentence report, the complaining witness had nothing taken, so there's no restitution, and any other terms set by the court. And we'd ask the court to sentence in accordance with that. I would just note in talking with Mr. Mullins that he's got a few other things to take care of. One thing we took care of yesterday was we resolved the outstanding warrant for probation violation before Judge Thomas. That's resolved. He's got something in Monroe County and he's got a parole hold. but eventually he is going to ask the probation department and ultimately the court to have his case transferred to Virginia once he's on probation, because his father's down there and that he thinks his dad and being with his dad can give him a fresh start. So we'd ask the court just to follow what the agreement, Judge.
All right. Anything, Mr. Lockviller, that you'd like to say, sir?
I did receive the pre-sentence report. I reviewed it. It appears accurate. We just asked that you adopt the pre-sentence agreement.
Okay.
Sentencing agreement, sorry.
Judge, there was just one other thing. I do note that the costs recommend $1,300 in court costs and things. And I don't, in this case, I don't think one size fits all. I recognize some bean counters have determined that's the appropriate amount to ask in every case. But in this case, this gentleman has a lot going on, and I just don't believe that would be fair or equitable to Mr. Mullins.
Mr. Mullins, what would you like to say, young man? She's about to turn you on. Now, Mr. Mullins, what would you like to say?
Thanks for everything you guys did. And hopefully when I get out, I can move out straight with my dad.
Okay. Well, Mr. Mullins, I'm gonna hope that's something that can be done. There are no restrictions. You'll have to go through the Department of Corrections to do that, but I'm sure your dad can't wait for you to join him so that you all can reach out and touch and support each other. One of the things that I'd like you to do while on probation is do some cognitive behavioral therapy, and that's the only thing that I would like. So it's a 2-year probationary term with the first 10 months in the Wayne County Jail. Like you said, since he is on probation, I'm sorry, parole, that there is no credit for any of the time served. And the only condition, like I said, would be cognitive behavioral therapy. That's the sentence of the court, 2-year term of probation. You don't have an absolute right to appeal your sentence and your conviction. You can appeal by leave. If you wish to appeal, can't afford a lawyer, want to be provided to you at no expense to you. Fill out the form, return it within 21 days from today's date. I'm going to waive costs and fees. Good luck, Mr. Mullins. So, Mr. Mullins, how old are you going to be next Saturday?
Next Friday?
I'm sorry. Yeah. No. Today is the 20th. Your birthday is the 20th. Yes, next Friday. Yes. How old are you going to be next Friday?
30.
Oh, man. You getting old, Mr. Mullins.
I'm getting younger by every year.
Oh, okay. Well, happy birthday in advance, young man.
When you say you mix of cards, what do you mean by that?
When I say what? One more time.
You mix of cards, the money. What do you mean by that?
Okay. Usually you have to pay some fees and some costs to go to court. I'm making it so you don't have to pay anything.
Okay.
So it's called waiving cost and fees. I am waiving the cost and fees that are associated with this case.
Okay.
Brandon, the response is, thank you, Judge.
No, that's a good question.
Thank both of you guys.
All right. Happy birthday again, sir, next week, Friday. You got me.
See you, Judge. Have a good weekend.
Thank you. Who you bringing next to me?
You have Mr. Espino at the other computer, Your Honor.
Okay. Are we ready with Andrew Robinson? Mr. Miana, are we?
Good afternoon, Your Honor. I am ready.
And I see Mr. Robinson is there. Yes, Ms. Smith.
It looks like you're calling cases from your docket, which I don't have. I only have the emergency docket. So could you give me a heads up when you call these cases?
I'm sorry, I certainly can do that. And I can give you the case number and say it slowly.
Thank you.
This is case number 21-2115. The young man's name is Andrew Robinson. And it's scheduled on my docket as a final conference. All right, your appearances, please.
Good afternoon, Your Honor. Steve Lockwood for the people.
Afternoon, Your Honor, Najad
Good afternoon, Nijad Mihani.
Good afternoon, Your Honor, Najad Mihana. Appearing on behalf of Mr. Andrew Robinson, P59371.
P59371.
Jaquetta, we can hear you. There you go. You're muted now. Thank you. So what is your proceed? What are we doing, Mr. Miana?
Judge, so this is a case in which we wrote a gun board letter. There is an offer. Mr. Robinson would like a short time to think about it.
What's the offer?
The offer is to plead to CCW, I believe, with a 30 days in the Wayne County Jail.
What is the offer, Mr. Lockbiller?
That is correct. Plead to count 3, carrying concealed weapon. It's got a 5-year statutory maximum penalty. We would have a sentence agreement, 2 years probation, first 30 days Wayne County Jail, 80 hours community service, and any other terms by the court.
All right. Do you want to come back on September the 8th, Mr. Mihana?
Judge, I will be out of the country on that.
Okay. How about October the 4th?
That would be wonderful.
That's Mr. Robinson. Mr. Robinson, you want to wait 2.5 months, 2 more months?
Yes, yes,
Okay.
I do.
No problem. See everybody on October the 4th on People of the State of Michigan versus Mr. Robinson.
Thank you, Your Honor.
Thank you. My pleasure. All right. Who do we have in the jail now?
Esther Espini.
Johnny Espino.
Okay. This is People of the State of Michigan versus Mr. Johnny Jesse Espino, 21-35-69. Your appearances, please.
Good afternoon, Your Honor. Steve Lockwood for the people.
Judge, this is a case in which the prosecutor is Ms. Rana Hadid.
And Ms. Hadid has been on, and I still see her on. Thank you. Ms. Hadid?
Oh, she is on the record, and Judge Knapp, Judge, she says she's almost done. She has texted me.
Okay.
Your Honor, we have Mr. Anderson in front of you at this computer.
Where is Mr. Anderson?
Ted Anderson,
Oh, okay. Let's do Mr. Anderson. Thank you.
you're welcome.
Judge, the only problem is I think Ms. Cox, I don't know, she might just complete her matter in NAP. I have that on the other device here, but so maybe she'll be here.
Oh, look at you all. Y'all are working me.
And Your Honor, Judge, we could do Mr. Viscapi.
Oh, Mr. Nan, thank you. Why don't we do that one? Ms. Smith, is that one on your docket? It's 19-7810 Harvey Martin Viscapi. Good afternoon. Your appearances, please.
Good afternoon, Your Honor. Steve Lockwood for the people.
Good afternoon, Judge Patrick Nine Eyes P76343 on behalf of Mr. Viscapi. We consent to a Zoom hearing today.
Can I offer my apologies for not having that one locked in, and let's try to lock it in one last time for this waiver.
I don't think it was ever intended to be locked in on this date, but
Thank you. I thought it was. Thank you. That makes me feel better, Mr. Lockbiller.
anything I can do to help.
Thank you. You actually did. Okay, so why don't you tell me the last offer, please, that was made? Let's see if Mr. Viscapi wants to accept that offer. The matter was waived. Is that correct? Is right to a trial by jury or no? Or am I?
It was waived to a bench trial, Judge.
Exactly.
That's correct.
So what was the
And
last offer? Thank you.
the last offer is to plead to an attempt. We would leave sentencing up to the court.
All right. Mr. Lockbiller, do you know if I've received a witness list?
I believe a while back you have, and
There's no problem at all.
I will get another one to
No,
you.
no, that's all right. I'll do the witness list. I'll do the jury. Oh, I don't need that. Witness list and the information. And let me give ourselves 6 or 7 weeks to get it together. So what are you thinking in the beginning of October?
Judge, I could do October 1st.
You know what?
Then that next 2 weeks, I have a federal trial.
October 1st, you know, we could set it for the morning because I have a C docket, an emergency docket in the afternoon. So let's set it for October the 1st at 9 o'clock.
That would be in person?
Okay,
Yes.
perfect, Judge.
And Stephen Lockbiller, if you would call Mark later when we end the docket to make sure that the names on the witness list are the names of the witnesses you want, so that we can submit that witness
No, he's
list
not talking to me
and
right now.
have those people approved.
Okay.
Okay.
Can you hear me, Patrick?
Yes.
Yeah, I can hear you.
We all
Oh,
can
okay.
hear you.
I just didn't know if you guys heard.
No, we got you. You doing all right today?
I'm doing great. I'm actually having this big lobster thing with my son right now, but he's scared the hell out of me driving with his permit right now. So I need to just sit down and relax and have a nice lunch with him.
Who's paying for the lunch is the question.
Daddy's paying.
Oh.
Dad always pays.
Oh, okay. Well, I want you to know if you had changed your name to crime, crime doesn't pay.
Yeah, I never changed it. I've been pretty good for 59 years.
Yeah. Okay.
Other than 2 mess ups.
Okay. Other than, yeah, I was smart except for 2 E's, right? Okay. All right. I'll see you in October, Mr. Viscapi.
October 1st, correct? At 9
That's
o'clock
right.
in the morning.
Down here at Frank Murphy in Courtroom
got you.
404.
Okay, thank you. We'll see you later.
All right.
Thank you, Judge.
Thank you. Bye-bye.
Okay,
Yes, Your Honor.
Patrick.
Mr. Tutters, we're still ready, Mr. Johnson and I.
Excuse
Okay,
me, Judge.
I'm listening.
Are all the parties here for Mr. Hassett or Mr. Lopez? I can swap them out in a chair if they are.
Judge, I'm here on Lopez, Rico Lopez.
Yes.
Good
we're
afternoon.
We
Good
are ready on the Lopez matter. And is that Ted Anderson in that other seat?
Yes.
Mr. Anderson's there, Judge.
Okay.
Good afternoon, Judge. I'm here on Jose.
Okay. Let's do Lopez because he just sat down, and then we're going to do Ted Anderson while they switch out Mr. Lopez. This is Rico Valdez Lopez, 214568. Your appearances, please, for the Lopez matter.
Good afternoon, Your Honor. Steve Lockbiller for the people.
Good afternoon, Your Honor. Samuel Chirikian appearing on behalf of Mr. Lopez, who's present by way of Zoom. We consent to Zoom proceeding.
Thank you. Mr. Lopez, tell us good afternoon, or it sounded. You can hear us?
Yeah, I can hear you.
Okay. Mr. Chirikian, what are we doing, sir?
Well, Judge, this one's a little complicated. The reason it's complicated is Mr. Lopez has a matter pending in Macomb County as well. And I just got off the phone with his attorney there, who is Joan Morgan, formerly of NDS and now working for the public defender in Macomb County. And I need some clarification from her. I would like to coordinate these matters. I'm also going to try to negotiate a resolution as to the felony firearm count in this case, in as much as what we're talking about is a BB gun.
My goodness. Well, if you were in Oakland County or in Washtenaw County, where they're calling their prosecutors rogue prosecutors for doing what looks a little bit like justice, it might be a little easier. I'm not sure what's happening in Macomb, but I can give you, yes, I can give you October the 1st, Mr. Chirikian, and perhaps that'll be enough time.
I suspect it will be, Judge. Let's make sure I'm just available on the 1st. Just give me a moment, please. Yeah, that's fine, Judge. October 1st?
And that's on docket C.
Okay, so that'd be 1 o'clock. Very good.
Do you understand what's going on, young man?
No, Your Honor. Actually, I don't. I went to Macomb County court this Monday, and they told me that they were waiting to see what's going on in Wayne County before they even proceed with any procedure, with anything.
Okay. Well, how about this? The two lawyers know each other and they're talking.
Yeah, but they keep bouncing me back and forth. They keep bringing me out to Macomb and then bringing me back to Wayne County. I got to keep doing this quarantine stuff, lockdown 23 hours a day. So it's a bit inconvenience to have to keep going back and forth.
Well,
is there any way I could talk to my lawyer in a breakout room after this, Your Honor?
Oh, that would be fine, Judge. No problem. You know, I know it's inconvenient to Mr. Lopez, but going to prison for an extra 2 years is even more inconvenient. So that's what I'm trying to avoid.
Are you happy with that explanation?
Yes, Your Honor.
All right. October the 1st. Give Ms. Morgan my my hellos when you speak to her next, Mr. Sharika, and especially the woman that you go home to. Tell her I said hello, please.
Okay, Judge, I'll do that. You
All
take
right.
care now.
Have a good weekend.
You too.
Thank you.
Right.
Now, Ted Mark Anderson, please. Case number 214070. Your appearances for the record, please.
Yes, good afternoon, Judge Carly Cox on behalf of the people, P81911.
Good afternoon, Your Honor. May it please the court. Mark Brown, my P number is 39562, appear on behalf of Mr. Anderson, who's present via Zoom from the Wayne County Jail. We have no objection to continuing this hearing via Zoom.
Mr. Anderson, can you hear us, young man?
Yes, I can. Good afternoon, Your Honor.
Good afternoon. I hope you're doing well as the rest of the people here.
Yes, I am. Thank you.
Okay. So, Mr. Brown, I have a couple issues and I don't know how to resolve them. I would love your input. For the pretrial investigation summary, it says that Mr. Anderson was unable to provide any references. And then there was another section that said that they were unable to verify the information that he provided them for the school number. It says if writer was unable to reach the school at the phone that was given, the phone number list online. So there was some inability to prepare to verify some of the information.
I understand, Judge, if I may. I don't have a copy of the DS report. I had an understanding of what the recommendation was. I'm sure that after 4 months being incarcerated, Mr. Anderson perhaps might not remember each and every telephone number, but he has a very strong support system in his family and otherwise. So I'm sure those matters could be worked out in terms of just providing telephone numbers. And I'm not sure he'd be working there immediately after he was released, if he was released anyway. So,
well, the concern that, I mean, the initial concern that I have is that if he's released and it's on tether, would he be going back to the 8106 East Jefferson, which is where he said he lived, or would he be going to live with some alternative person? I see Tracy Anderson. Is she related to Mr. Ted Mark Anderson?
I believe so, Judge. I did see her on there. The
Tracy Anderson, unmute yourself, please.
Yes, I'm his sister.
Okay.
It's my understanding. I was of the opinion that he was supposed to be going back to his apartment, Judge. That's my on East Jackson.
Okay. Okay.
And
were you privy to the I'm sorry, it's not even a pre-sentence report, to the pretrial investigatory summary that was prepared in this matter?
No, I was not, Judge.
Okay, would you like me to read the recommendation section? I think that would not be considered confidential.
That would be wonderful, Judge. Thank you.
Okay. Pretrial services must consider the assaultive nature of the charge, which carries up to a life sentence in prison. Also of concern is the complainant's minor age at the time of the alleged offense. Another concern is the defendant's inability to provide any references. For these reasons, this writer finds substantial monetary bond necessary to make likely both the defendant's return to court in compliance with the Bail Reform Act and protection of the public in compliance again with the Bail Reform Act. This writer finds that these purposes could be served, however, were there a reduction in bond. This finding is based on the defendant's minimal prior record. The writer is also mindful of the age of the alleged offense dating back to 2007. This writer notes as well the defendant's lack of low risk level of 1 on the risk assessment tool based on the favorable factors of reported length at the time of the same residence, reported marital history, divorce status, a reported college background, and reported full-time employment. Therefore, this writer recommends a reduction in bond to $100,000 cash, surety, or 10% with continuation of the condition of the Wayne County Sheriff's GPS tether and no contact with the complainant directly or indirectly, and a provision of no unsupervised contacts with minors of any age. And I don't think that minors probably would be what they would want to say. They would probably want to say female minors, as opposed to generally just minors. But that's the recommendation.
Thank you for that information, Judge. I believe at this time that the bond is currently set, I believe at $250,000 cash surety or 10% is very reasonable given the allegations in this case. I do wish that the court had an opportunity to review the preliminary examination transcript. I know that your clerk has been searching high and low for it over the past couple of weeks, and counsel has reached out to court reporting services as well. The allegations in this case, Judge, are they're extremely serious. And there was continued contact by the defendant to the alleged victim in this case for many years after the sexual assaults stopped happening. The alleged victim in this case was Mr. Anderson's student for a time. He drove her places, he groomed her. He really took advantage of what I would say a victim in a very vulnerable position. At the time of his arrest, he was still teaching. I'm unaware of any other allegations by any other students, but I do believe he's a danger to the community, and the bond is commiserate with the alleged offense in this case. So I would ask for no bond reduction.
I am almost certain that I read the transcript, and I'm looking for a copy of it now because I think I remember the allegations. I remember the testimony in terms of picking him up in one jurisdiction and then driving them down to his apartment downtown. I think she was at the bus stop the first time. No, I'm pretty sure I read the transcript in preparation and was just waiting on the pretrial investigatory summary as it relates to his prior record and contact made with persons to establish the likelihood to return to court and the likelihood of conviction. Because basically that's, what the Bail Reform Act deals with, the flight and the person's danger to the community. And you said something that was significant, and that is that you have not been able to corroborate any other behavior that Mr. Anderson has exhibited similar to what is charged in this particular case. So we don't have any 404B issues or anybody else that has come forward. And the date of this complaint that I see in the investigator's report says that the complaint was made 5/24/16. And when was the warrant signed?
It was signed, Judge. Sorry if I can just check real quickly. I believe it was in March of this year. It was April 6th of this year.
And do you know what happened, transpired between the date of the complaint that's on the investigator's report? And
I do.
Okay, so what happened those 4 years? Because the date on the investigator's report lists November the 5th, 2020.
The officer that was previously assigned to the case was transferred out of DPD sex crimes, and the case unfortunately just sat over there for many years until the alleged victim went to the police department and asked what the status of the case was. She made police reports in Inkster from 2013 through 2015. And I just was presented, and I let Mr. Brown know this too, I was presented with a warrant request from the Dearborn Police Department as well as the Inkster Police Department on the same facts with the same victim. And there was just, the reason why she kept on making those police reports, Judge, was because the defendant kept contacting her. She's always been afraid or just trying to be heard and someone to help her keep him away from her.
A couple things I like, May.
Yes, Mr. Brown.
Number one, she said that she had a, I guess it's a new matter or something from Dearborn and Inkster rising out of the same facts. So this is a matter of investigation that has been going on for 8 years, and then it's new in 2021, supposedly, but it's the same persons, same two people, and I hope there's something else. And I don't know, maybe tomorrow we'll have a new one, which is the same thing out of the same facts with the same two people. One thing, and I would indicate to the court that what is, I think, very significant, you've alluded to this, is that the fact that between 2007 or whatever date we're talking about, there's no problem with Mr. Anderson and anyone else. There's not, that isn't something that's going on. So I would suggest to the court that he does have very strong ties to the community. I understand the seriousness of the charges in this case, but he has very, very strong family support. I've been in contact with members of his family since the outset of this matter, and he has no intention to do anything other than defend against the case and stay in this jurisdiction.
Is there anything else, Ms. Cox?
I just want to add the reason why the complaining witness did come forward again to check on the case at DPD was because she had just started a new business, and she did testify about this at the preliminary exam. And Mr. Anderson reached out to her via email, and she's, like I said, I can say it a million times, Judge, she's just very, very concerned about continued contact attempts by him, which I think also are indicative in the way that she testified at the preliminary examination about the numerous police reports that she made in Inkster and Detroit as well about him trying to contact her. So I do believe that he is a danger to at least her. We don't have other cases, but I am worried about any contact attempts with her.
Okay, thank you. The recommendation was based on, I think, factors that take into consideration his prior record, the long employment, his ties to the community, and the seriousness of the offense. I think that the bond that was recommended is a substantial bond of $100,000, 10%. So I will grant the motion and reduce the bond to that which was recommended in the report. I'll put him on a GPS tether likewise, and he is to have no contact, nor family members or anyone with Kiera Dallas.
Thank you, Your Honor.
Thank you. And let's see.
Judge, what
Yes.
was that bond?
The bond is 100,000, 10% with a GPS tether, and no contact with Kiera, and it's spelled K-I-E-R-R-A Dallas. Dallas.
Okay, got it. Thanks.
Ms. Cox, I'm not sure, based on everything that you've said, if all the discovery or the complaints that have been made in various jurisdictions, that you've gathered them or provided them to Mr. Brown. So you have to help me with where all the discovery is, or if it's been now accumulated by you in these different jurisdictions that you've talked about.
Sure, Judge. I did forward Mr. Brown, when I got the warrant request from Inkster, the entire packet, which was only the number of pages I think were in the teens. So, and that was already some, is the same information that he's been provided with since the beginning of the case. I haven't given him anything from the Dearborn case yet. I did talk to him about it yesterday. I just need to follow up with those agencies and Ms. Dallas, and I'll notify Mr. Brown as soon as there's a decision made.
Okay. Is it too early to ask if we can figure out where all of this is going and have some direction by the 24th of September?
I think that that's a fair estimate. At least we can update the court on everything if we need to call you and have a in-chambers meeting before.
Oh, absolutely. Absolutely.
Fine with me, Judge.
Okay.
Perfect.
So that's going to be on docket B, 924 on docket B for Mr. Anderson. And if he makes bond, we'll still keep that as a call-in date because that docket is short and we should be able to talk as long as we need to complete what and have whatever discussion we might have for scheduling in advance of that.
Perfect. Thank you, Judge.
Thank you, Judge.
Thank you much. Okay. Thank you, Division 1. Appreciate it. Okay, what's your name, young man? I'm sorry. I was told what your name is and I can't remember now.
For me?
Yes. No, not,
Isaiah Evans.
I see you, Isaiah. I'm talking about in the jail. Yeah.
Oh, okay.
Mr. Hassett?
Thank you. I appreciate that, man. I don't know why I can't keep it all together. Mark, for Thomas Allen Hassick, 215221, I see it's Kathleen Toules, and I don't see her on.
I'm right here, Judge.
Where are you?
Right here.
Where is right here? Because if I saw you, I could see you. Okay, anyway. Mr. Hassick's there, that's fine. We can call the case. This is case number 215221, Mr. Thomas Allen Hassick. Your appearances for the record, please.
Good afternoon, Your Honor. Steve Lockbuehler for the people.
Good afternoon, Your Honor. Kathleen Toules, appearing on behalf of Mr. Hassett.
And Mr. Hassett, good afternoon to you, sir.
Good afternoon to you and your staff, Your Honor.
Oh, you're such a polite man, Mr. Hassick. My staff, my one-person staff is happy to be appreciated.
Al, I haven't heard anyone mention it today, and I do appreciate what you guys are doing, so thank you.
Okay. So, Ms. Toules, now I see you loud and clear, or see you without the rain clouds in the way. What are you all working on for Mr. Hassick?
Your Honor, I have not been given an offer yet for him, but at the exam, I talked to the prosecutor and she said that she would write on the file that she would recommend diversion if he could pay back the $1,500 that's at controversy in this case. My client will have no chance of doing that if he is locked up in the jail. I know the pre-sentence report says no reduction in bond, but I would beg you to consider a personal bond for my client so he can get out, go to work, and get this money paid back.
What is Mr. Hassick's bond presently? Jail?
I believe it's 5,000, 10%.
Hold it, $500. Ms. Hassick's in jail for $500.
I believe that's what it is, Your Honor, and he can't afford to make that bond.
Talk to me, Mr. Hasek. You're muted now.
Yes, Your Honor, I apologize. I can actually semi afford the bond. However, I've learned through the bonding officer here at the jail that the only reason why I am not released from a bond, as well as other bondsmen, I'm supposed to have a tether bond. However, I'm ineligible from an absconding charge that was attached to an old warrant from roughly 7 years ago. I've paid my court fines up there. I've just lived down here, maintained a company, worked. I've been arrested 4 years ago when I was advised and released from this county with the absconding charge. I've had time to maintain and grow into an adult rather than a young punk. But that is the reason why I cannot do the bond, is because of the tether.
How much money do you and your family have, Mr. Hasek, for bond?
To be honest with you, Your Honor, I don't know. My fiance and I have 2-year-old twins and a 9-year-old in the home. I've been incarcerated for a month now. So I can't tell you that without speaking with my fiance.
Well, where does the family live?
Lincoln Park.
Where does her family live?
All around Wayne County.
And where does your family live?
I don't have much family left other than one sister in Tennessee and one sister in Allen Park, roughly a mile down the road from where I live.
Okay. Well, now see, what you told me, Mr. Hasek, has me thinking this. If everybody pitches in $100, you can get out on a bond of $500 cash.
Yes, Your Honor.
So that's what I'll make the bond, $500 cash.
I appreciate that, Your Honor. And what do I do about the tether portion of it?
What did I just say? I'm going to make the bond.
Thank you, Your Honor. You stated $500 cash bond.
That is correct. Did you hear me say anything about anything else?
No, Your Honor, I did not.
Okay, Mr. Hasek. So it's $500 cash to get out.
Thank you, Your Honor, so much.
Ms. Toulas?
Thank you, Your Honor. I appreciate that.
Let's hang out on docket C on 9/16, okay?
Your Honor, I do have an offer.
Thank you.
I can put it on the record. I did email it to defense counsel this morning, I believe. The offer is to plead to count 1, attempt larceny by conversion, and restitution as well. So.
All right.
I will check my emails. Thank you very much, Your Honor.
No problem. See you all back then.
All right. Everyone have a wonderful weekend.
Thank you. Ms. Henry, are we ready on Mr. Godecki? Ms. Henry. In division, young man in the jail, what is your name? Oh, look at him running.
Mr. Espino, first name Johnny.
Yeah, okay, you again.
Unfortunately, Judge, sorry.
That's all right. We're ready with you because I see Mr. Mihana. This is Johnny Jesse Espino, 21-35-69. Your appearances, please.
Good afternoon, Judge, and to your staff. Rana Hadid on behalf of the people, P62243.
How did that other hearing go for you?
It went.
Now, do you ever regret the expression, I wish I could clone myself?
Yes.
Okay, because this is cloning. You know that, right? This is the closest that you're ever going to get to human cloning.
Yeah, I don't like clones.
Right. I don't like clones either. I like one place at a time.
Thank you for reading, though. I appreciate it.
So what are we doing today? Bring me up to speed, please. And you're muted, sir. Mr. Mihana, you're muted.
Good afternoon, Your Honor. Najad Mihan appearing on behalf of Mr. Espino, P59371. This is a case in which we are still awaiting the transcript.
Oh, my Lord. When was it ordered, Mark Ulatowski, please? And what is Mr. Espino shaking his head for?
I've been waiting for like 2 months.
Well,
I'd also like a bond reduction too, Judge, if I can.
oh, you think I'm just giving out bond reductions, huh, Mr. Espino?
Well, I've been observing it and I humbly asked for a bond reduction too.
Oh, now you're gonna get humble on me.
Yes, sir.
Oh, okay. John, why is your client getting all humble now?
I have no idea, Judge. Being locked up for quite some time at Wayne County turns everybody to be humble.
No, it makes some angry now. Come on. We got some angry people. I don't know if I would be humble or angry. I'm probably angered more than humble. Because plus, I would probably be hungry because the food isn't good either.
Nothing is good about it. Place is falling apart.
Well, you know, as sad as this might seem, jail still is a lot better than some people's homes.
True.
Because at least the people that are carrying guns, you can't see them in your house. They're walking through with the weapons out. So, Mr. Ulatowski, any idea when the transcript for Mr. Espino is going to be around?
I ordered them on June the 17th to be due on July the 16th, and they're still not there. I will have to call Mr. Richards Monday morning to find out what's going on.
Wow, that's scary.
Or Mr. Joseph, I mean, sorry.
Ms. Hadid, what was the offer for this young man?
Your Honor, the offer was to plead to 1 count of assault with intent to murder, 1 count of felon in possession of a firearm, and 1 count of felony firearm with a sentence agreement of 10 to 20 years in the Michigan Department of Corrections with an additional 2 years for the firearm count. That is taking into consideration that his guidelines as charged run at the bottom end at 10.5 to 17.5 years without the habitual. With the habitual, they would go up to 35 years.
Okay. Mr. Miana, what is your ultimate goal? Do you have one in mind for Mr. Espino?
Yes, Judge. Based on this offer, the ultimate goal was going to be to file a motion to quash and then more than likely to proceed towards trial.
Okay, well, there's not much that I can do except to give you another date and ask you all to keep me apprised about when the transcript gets here. I'll put a little note in when I come in on Monday to call Mr. Josephs to shake the cage to where it might be, so at least we can have that done, because we can't even get close to being certified to go to trial without the motions being heard and decided. So October the 1st, surely that should give us enough time, I believe, to have all of that is necessary to put ourselves in that position. So can we do that?
Yes, please. Would that also be a C docket?
Yes, it will be.
Okay.
Boy, you're pretty perceptive there.
Your Honor, can I say something too?
Yes, you may, sir.
In regards to the bond reduction, Your Honor?
Yes.
Mr. Espino, I can tell you that Judge Morrow usually would like to read a transcript to address bond, especially on this type of a charge. If I'm wrong, please correct me, Judge.
Oh, you're so right. I need the transcript so I can determine the likelihood of conviction, Mr. Espino, because that helps me to decide what bond is reasonable.
And can I also add, the first deal that she said on the record was for me to plead guilty to assault with intent to do great bodily harm, less murder.
No, I said assault with intent to murder.
That's not what you said the first time.
Well, that's the offer that I said today. If I misspoke, then that was incorrect.
She stands corrected. Thank you. We all make mistakes. I've been making a ton of mistakes today. Haven't you heard of Mr. Espino? You know, I see one person, can't find somebody else. I'm glad I'm getting a lot of help trying to make everything correct. So we're happy that you wanted that corrected and came with what you remembered so that it could be corrected, so you wouldn't be mistaken about what's being offered. But I'll see you back in October, young man. And by that time, your lawyer should have the transcript, can make a bond motion. I will have read it. The prosecution, of course, will have a chance to respond, and we will be ready to provide you with whatever justice is required on that day. Okay, Mr. Espino?
And
Thank you,
Your
Your
Honor,
Honor.
Your Honor, is it possible to also have a DSU report if there isn't one in the file to be ready for October the 1st?
We'll try to have every iron in the fire, sir.
Thank you, Judge Morrow, and the prosecutor and everybody else. Have a wonderful weekend.
Thank you. You do the same.
Thank you.
I'm excited. All right. Yes, sir.
Your Honor, I have a question.
Low battery request to do Mr. Leon Kennedy before the prosecutor's battery dies.
Okay, let's do Mr. Leon Eugene Kennedy. This is 21-2418. Your appearances for the record. I've been told.
Thank you and good afternoon, Your Honor. APA Larry King for the people, P78774.
Good afternoon, if it may please the court. Sarah Robinson, P63181 for Mr. Leon Kennedy, who is out of custody. He is on Zoom. We consent to Zoom.
Mr. Kennedy, give us your name and tell us hello, sir, please.
Hello, how's everybody doing? Mr. Leon Eugene Kennedy.
Thank you, Leon Kennedy. Okay, I got a motion for demand for production of discovery. Is that what we're talking about today?
That is, Judge.
Thank you. So what do we need my assistance for, if anything?
Well, if I may, Your Honor, this motion was before the court today for a hearing regarding some missing body-worn camera. I had subpoenaed the officer in charge of this case, Calvin Washington of the Detroit Police Department, who would have the answers to that. And before we came on for the hearing, I called his office just to remind him, to tell him he's expected on Zoom and he's under my subpoena, only to be told by his supervisor that he is out with COVID-19 and has been for a little bit and is not expected to return to work until next week. Since I think he's the one with the answers that we need as to where this body-worn camera is, I would ask the court to adjourn this matter to allow him to recover from his illness and be with us next time.
What do you have, Ms. Robinson? Any objection?
I can't object if someone is sick, Judge.
Okay, let's do this on a date that is not crazy. So can we do it on another in custody date, the 8th of September on docket D?
Works for the people.
Yes, Judge.
Thank you. I appreciate it. Mr. Kennedy, the guy got COVID, man.
No, it's crazy.
Well, well, that's the whole point. I hope he does too. So I'll see you on September the 8th on docket D.
Thank you.
Appreciate your time. Thank you, Your Honor. Have a good afternoon, everybody.
All right.
Everybody have a blessed day.
Thank you. Are we ready on Mr. Gardinas? Mario? Where is Mario? Where's Mr. Gardinas?
Mr. Gardinas is in my office, Your Honor.
There you go, hiding. This is case number 203993. Mr. Mario Gardinas, your appearances, please.
Good afternoon, Your Honor. For the record, Musabi Hamid, P34663. Appear to be having Mr. Mario Gardinas, who is here in my office. Mr. Gardinas, say hello.
Hello, my name is Mario Gardinas.
Thank you, Mr. Gardinas. Thank you, sir. All right, so what are we trying to accomplish and how close are we to accomplishing it?
We are, the prosecutor and I are asking for a couple week adjournment, Your Honor. We're trying to negotiate and finish up a deal.
Okay, pick the 8th or the 16th.
Okay, pick the 8th or the 16th.
I can hear you, Miss Smith.
September 16th sounds good, Your Honor.
Okay, that
Mr.
would be on,
Lockbeller put his appearance on the record. He was cut off by Mr. Hamad when he was trying to.
Steve Locklear for the people.
okay, September the 16th, it will be on docket C.
Boy, that's a nice memory.
At 1 o'clock, Your Honor?
Yes, sir.
Thank you. We ask the bond be continued.
It will be, and I'll see you on that day, sir.
Thank you, Your Honor.
Thank you. Ms. Henry, let's go back to Mr. Gadecki.
Ready, Your Honor.
This is 21-1497, Joshua Carl Gardecki. Mr. Gardecki, what you got? Who's appearing on behalf of everybody?
Can we get that evidence? Steve Locklear for the people.
Good afternoon, Your Honor. Kathy Henry appearing on behalf of Joshua Kodecki.
Okay. Mr.
Good
Gadecki,
afternoon, Your Honor. Mr. Gedeke here.
you doing all right?
Yes, sir.
You look kind of mean today. You don't usually look mean.
No, sir. I'm okay. I'm okay.
Are you sure?
Yes, sir. Yes.
Would you tell me if you weren't?
Yeah.
Okay.
I apologize about that. I just got an incoming call. I hurried up and declined.
Okay. All right, Ms. Henry, what are we up to?
Your Honor, the prosecution did make me an offer, although I wanted a better offer, and because I can't make out a factual basis, or my client can't make out a factual basis with the offer that he offered. So I'm hoping to maybe have it changed. And so we probably need to just put it over to see if that can happen.
What is the offer as it presently stands?
It's delivery of controlled substance, and it's a dismissal of the habitual. And I can't make out. I'm sorry?
Also dismissal of count 3.
Count 3. Which was habitual.
Another delivery and manufacturing.
Okay, but it was still, he was basically, the facts that he can provide won't support that. So I would like another date maybe just to see if the supervisor would be willing to reduce it to just possession.
Could I put you on 9/24, ma'am? You and Mr. Godecki? Godecki.
That's, oh, wait a second. I think I'm out of town that day. Oh, I'm out of town that day.
Well, you're not in Detroit right now. So technically, you're out of town already.
That's true. I could actually do it though. I could. I'll just, oh, but it's at 1 o'clock. No, I can't. That's gonna mess up. Yeah.
Okay, 9/24 at 9 o'clock
That's better.
on docket B,
Docket B.
emergency docket B, 9/24 for you and Mr. Godecki.
That's at 9 o'clock, right?
That is right, September the 24th.
Okay.
I'll see you all back on that date. Thank you.
Thank you,
Your Honor.
All
Thank
right.
you. Have a good day.
Thank you. You do the same.
Okay.
Daniel Harris.
Ready, Your Honor.
Yes, sir. This is Mr. Daniel Harris III on case 19-8476. Your appearances for the record, please.
Good afternoon, Judge Morrow. Susan Dillon, P72904 on behalf of the people.
Good afternoon, Judge Marco Bisbikis on behalf of Mr. Harris, P number 79478. Mr. Harris is present here via Zoom and waives any objection to Zoom and appreciates court taking us today. Mr. Harris, say hello.
Good afternoon, Daniel Harris.
Okay. So we need a hearing. Is that what we need?
We believe so, Judge.
And we need a in-person hearing?
If the court could entertain that, we would appreciate that as a defense. If we can't do it in person, Judge, then, I mean, we would be okay with the Zoom, but we would just much rather prefer an in-person so we can have the proper confrontation.
This court feels that there's only one way to have hearings and trials, and that is in person.
I like that, Judge.
All the rest is Memorex. Ms. Dillon, do you remember that commercial?
Absolutely, Judge. I
Is it-
remember the ad with the guys, wasn't it, is it Memorize, is it real or is it Memorex,
it-
and his hair was blowing back?
Right, that's exactly what it is. Is it real or is it Memorex? And
Yeah.
it's like the difference between watching a movie and going to the theater on Broadway. Which would you rather do? I'd rather, I would call the theater in Broadway what it's about.
If it's a good show, it's definitely worth much better than going to a movie.
Oh, absolutely. Okay, what I'll need is for the names of the witnesses to be provided to me, please, so that I can get this through the right committee and get us permission. What I'd like to do is to do it on one of my in custody days that's in the afternoon and schedule it for the morning. So October the 1st, I'm on docket C in the afternoon. So could we schedule it for the 1st of October at 9?
Since it became expensive.
That should work for the people, Judge.
Works for the defense, Judge.
Okay.
Your
Ms.
Honor, I'm sorry.
No, go ahead.
Judge, I wasn't sure if this was defense motion to suppress, I believe, the sexual assault kit or the DNA evidence. There wasn't a specific item mentioned in the motion. So I'm not, I guess I would have to know from defense who they may want that I need to get.
There's, I believe it's 4 or 5 officers with the issue to the chain of custody that's portrayed here. I can give you the exact check-in, check-outs. I believe some of the names we may have to find out from the other officers because the report said it was illegible, the names. So we might have to get the other names from the previous officer who checked them out or checked them in from.
So why don't the two of you talk about it? Send me a list of the names so I'll know who to tell the security downstairs to allow in at the hearing date.
Okay, Judge, no problem.
All right. Well, then I'll see all parties 9 o'clock on October 1st.
Okay.
Ms. Dillon, I'll call you Monday morning and we'll go over that together then, or Monday afternoon.
Whatever works, that's fine. Thank you.
Thank you. Have a great weekend.
Have a great weekend.
All righty, you too.
Have a good weekend.
Thank you. Are we ready, Ms. Barnwell, on DeAndre Haggard?
Yes, Your Honor, give me the opportunity to turn down this other Zoom.
Yeah, turn down that other Zoom.
Yeah, turning this volume down.
All the way down.
Yeah, my headphones aren't responding anymore. I did buy some wireless ones, but I don't know how to do it.
Could be a problem.
I know my sons have to show me. They're a little impatient with their mother.
Imagine that, a child impatient with their parent. What will happen next? All right, this is DeAndre Roshan Haggard, 21-37-67. Your appearances for the record, please.
Good morning, good afternoon, Your Honor. Steve Lockwood for the people.
Good afternoon, Your Honor. Wendy Burnwell on behalf of Mr. Hagar.
Okay, so what are we doing, ma'am?
Mr. Hagar should be on the Zoom.
I'm here.
Okay. All right.
Yes, Ms.
Judge,
Brown?
my client is ready to sign, but I have not printed that out, the form.
What is he pleading? What does he want to plead to, ma'am?
It's the count of CCW as a second habitual. This was a case where he had initially thought that he had pled on a prior case to a misdemeanor with respect to a gun, but or respect to something else that was actually a felony. Mr. Lockbeeler looked it up, indicated that was a felony, so he wishes to plead. The only thing is that the form that Mr. Lockbeeler sent me has not been signed yet.
Mr. Lockbeeler, what is he being charged with and what is he being offered, please?
There's no offer on this. He would just be pleading straight up to the charge of CCW as a second offender. Habitual offense.
All right, Mark, if you will, can you meet me so I can get the file and have the information? I'll be
Coming back.
Okay, thank you.
Yeah, I did send you a plea form that
Yeah, thank you.
To hang tight. The Evans and Evans. It's Alvin Salem. Beyond there, they called him. He's got.
Excuse me.
Second, Isaiah.
Excuse me.
I see Salem there.
Date for Evans.
Can I say something?
Just hold tight,
on the
man.
record on another case right now.
I'm in
Good afternoon,
charge.
Your Honor.
Hold tight. I'm sorry.
Okay, I don't have an execution date for Evans and Evans, so did you tell them just to wait?
I'm in court.
No, I didn't tell them any. I haven't even acknowledged him.
I just got a note.
I'm in court. I'm in court with another case.
And did we get one for Isaiah Evans? Okay.
I'm in court with Judge Morrow, Judge. Oh my goodness.
Mr. Salen, hang tight. I'll be with you in 2 seconds. Okay?
Judge, I'm in court with Miss Judge Morrow. I'm on the record. Okay.
Okay. Mr. Hagar, do you promise to tell me the truth, young man? Okay, I need your name and your age, please.
First name DeAndre, last name Hagar, age 30.
Mr. Hagar, you're charged with carrying a concealed weapon and the second offense notice. What that does is it 1.5 to 5 years. So you're charged now with an offense that carries up to 5, but with the second notice, it's 7.5 years instead of 5. It's a probationable up to 7.5 years in prison. Do you understand what you're offered? And I'm sorry, what you're pleading guilty to and the amount of time that it carries, sir?
Yes, sir.
Okay, has anybody promised you a particular outcome?
No, sir.
Are you pleading guilty, sir, because you want to plead guilty and because you are guilty?
Yeah.
Has anybody forced you or threatened you to make you plead guilty?
No.
Why are you pleading guilty today? Is it because you are?
It was okay. It was my girlfriend's firearm in my vehicle. We shared cars, and it was just left in there when I jumped in the car. So I mean, I guess I am.
Well, no, there's no. In order to be guilty of a crime, so you have to be aware that you're committing a crime. So are you telling me that you weren't aware of the gun being in the car because you can't plead guilty if you are? Or are you just BSing me and you really knew the gun was in the car, and who cares if it was your girlfriend's gun? You knew the gun was in the car and you drove around with the gun in the car.
It wasn't at that point, it wasn't like that, but I mean, I knew. I went to work and then she told me, and then like I stayed at work, and then when I went to work, I mean, when I was on my way home, of course I knew it was in the, in the vehicle on my way home. I didn't know initially when I got in the car to go to work.
Where was the gun in the car?
It was under the seat.
Oh. And you left it under the seat and you got in the car knowing that it was under the seat and you drove anyway?
To go home, yeah.
Well, I don't care where you went. The fact was that you knew that there was a gun that was in the car when you got in, and you drove with the gun in the car.
Sure.
I mean, you can say sure, but you're the one, man. You know it's illegal to ride around with a gun in a car, sir? Whether
Yes,
you're on your way to work, to the store. You understand that?
I understand.
I'm sorry?
I said I understand.
Okay. If you wanted to, sir, you could go to trial. At trial, you would be presumed to be not guilty, and you would have a chance to confront your accusers. At trial, sir, you could present a defense if you had one by calling witnesses, being a witness for yourself, offering diagrams or exhibits, or by doing nothing. Nothing is acceptable because you don't have to prove yourself to be not guilty. The prosecution has to prove you guilty beyond a reasonable doubt. At trial, sir, if found guilty, you could automatically appeal whatever verdict was reached and whatever sentence I had to impose. By entering a plea of guilty, you're giving up your automatic right to appeal. Do you have any questions about the rights or the rights that you have that you're giving up by entering this plea of guilty?
No, sir.
Did this offense happen January the 14th of this year at Greenfield and Schoolcraft in the city of Detroit?
Yes, sir.
And how is it that you believe that the police, or why do you believe that the police stopped you, Mr. Hagar?
Because of the type of vehicle that I drive. I drive a Dodge Charger.
So you think they stopping Dodge Charger drivers?
Yes, sir. Because there's a lot of auto theft going on with these cars. So of course I already know what it comes with. They're gonna get behind the car. They're gonna run the plate. And I didn't have insurance at the time, so that's why I was pulled over.
So you knew you didn't have insurance. You knew you had a gun.
No, I didn't know I didn't have insurance. I didn't know that. I did not know I didn't have insurance.
Okay, you still know they're gonna pull you over anyway, right? Because of the type of car.
Well, no, I didn't think I would get pulled over. I know they'll get behind me and they'll kind of read the plate, but I didn't know I was going to get pulled over.
So her car or your car?
We share a vehicle. It's in my name, but we share a vehicle.
Okay, but it's your car and you didn't know your car was not insured.
Correct, because it had just recently expired, like that week.
Well, usually they send you a notice of payment and you know if you paid it.
Yeah.
I know when my insurance is due, and I know when I ain't paid it.
Well, insurance policy in my girlfriend's name, so it would have come to her first. It wouldn't have come directly to me. Like I'm on her policy through insurance.
So y'all share your car. She pays the insurance. She didn't let you know, and she didn't let you know that a gun was in the car. Seems to me, young man, you need a new woman.
Right.
What do you think, DeAndre?
Maybe.
I mean, her gun in the car. She didn't tell you the car wasn't insured. She set you up.
It's a messed up situation. Right?
I would agree. Okay, both sides satisfied with the factual basis, and I've complied with the court rule in the taking of the plea?
Yes, Judge, the defense is satisfied.
Okay, we're going to set sentencing for October the 4th. You need to call this number, Mr. Hagar, 456-4600. 456-4600. Let them know, young man, that you need to be interviewed for your pre-sentence report.
Okay.
And I'll see you back 9 o'clock on October the 4th. Thank you, thank you, thank you.
Thank you, Judge. I did have I was waiting for you to email me an order declaring someone indigent. Not this case.
I signed it. I didn't know you were waiting for Mark to email it back to you, man. But I signed it a while ago. So not quite sure what you meant by wanted. I didn't see any note attached to it. I just put it in the file.
Thank you, Judge. I'll
Okay.
email Mark.
No problem. This is case number 20-1226. This is Devontae Clifford Evans. Mr. Evans, thank you for your patience.
How you doing?
Isaiah, we'll get to you too. So thank you for your patience if you're not back on yet. Mr. Evans, there's a young man who is pictured on the screen with us. You'll see his first name is Elvin, and you'll see his last name is Salem. And he has been assigned to represent you. So Elvin Salem, that's Mr. Evans above you or next to you or below you.
Thank you, Judge. I do see him.
Okay.
And Your Honor, I have, just for the record, I have sent my contact information to Mr. Evans asking that he contact me. I can certainly give him my email address again so he can write it down. It's Salem Law, ASALLEN Law @gmail. Mr. Evans, please contact me with your phone number and your cell phone number. Judge, I've also been in contact with Mr. Casey, who is the APA on this case, and I'm making arrangements to get all the discovery and pleadings. So we will need another date on this matter.
Can I please get that email again?
Can we set this matter just for scheduling on October the 4th at 9 o'clock on my personal docket?
That's good with me, Your Honor.
Please get that email again.
Okay.
I have one moment. I think Mr. Devontae Evans is asking for that email again.
Salem Law, ASALLENLAW @gmail.
And Judge, Mr. Glenn's appointed to Isaiah.
Who was appointed to Isaiah? I'm sorry.
Mr. Luther Glenn.
Okay, so Isaiah's back with us. Hey, Mr. Evans.
How you doing? Yeah, I apologize. I had lost connection.
No, that's all
Judge,
right.
may I leave? I have another Zoom I have to get to. Thank you, sir. Appreciate it. Have a good weekend.
So Isaiah Evans, you with me?
Yes.
Okay, if you look on the screen, you'll see a face and a name, Luther Glenn.
Okay, hold on. Yeah, Luther Glenn?
Yes.
Yeah, I see him.
Okay, that's who the court has assigned to represent you.
Okay.
Okay, so this is, again, this is the same case, but case number 20-1226. Mr. Isaiah Evans is listed as 02. So, Mr. Glenn, if you'll place your name on the record, please.
Sure. Luther Glenn appearing on behalf of Mr. Evans, P38683.
Okay. And Isaiah, do you want to give Mr. Glenn your number so that you all can call and hook up? And
yes. Ready?
Yes.
Take my number now.
Yeah.
Okay, it's 313-358-7188.
Okay, 313-583-7188.
No, 313-358-7188.
Okay.
358-7188.
Got it.
Okay.
I'll text you my contact information after the hearing.
And again, like with Devontae, we've set this for 10-4 for pretrial
Okay. Morning or afternoon?
in the morning at 9 o'clock.
That's good. That's a good date and time.
That's
All right.
good for the people as well.
Thank you.
Okay, you said our next court date would be 10-4?
Thank you. Yep.
Okay, what time?
9 o'clock, sir.
Okay.
Okay, thank you.
Thank you.
This is People of the State of Michigan versus Dominique Johnson. Mr. Tuttles.
Good afternoon, Your Honor.
Yes.
Afternoon. Yeah, thank you so much for everybody's patience as we're rolling on. So where are we and what are we doing?
Are you ready for my opinion?
Yes, we're ready for your appearance, sir.
May it please the court, Mary Ann Bruder on behalf of the people, P55239.
Mr. Tuttles, would you place your appearance on the record, please?
Yes, may it please this honorable court, Antonio D. Tuttles on behalf of my client. That is Mr. Dominic Johnson, who is physically not present in your courtroom at this time, Your Honor. We do ask you to waive his physical presence. However, Mr. Johnson is present via Zoom. Mr. Johnson, can you raise your hand and identify yourself for the record? And my number, my P number is 64158 for the record.
Thank you, and thank everybody for their patience coming in and out. This has been one of those fabulous Fridays. What can I say? All right.
That is true.
What has been accomplished since last we met with your client and this case? Anything?
Yeah, Your Honor, I believe Ms. Bruder was, I'm not sure that anything of substance. I believe Ms. Bruder was going to try to find a possible potential plea that did not include a sex offender registry. I'm not sure if she was successful in that effort. And if not, Your Honor, we should be headed towards a trial docket.
Your Honor, I have taken the facts and circumstances in this case, and I tried to find
Hello, Ms. Bruder, did you hear that?
I did, Mr. Tuttles, I'm responding. Can you hear me?
Okay. Yeah, I can hear you now.
Okay, so I have tried to find what I would deem an appropriate plea that would be a misdemeanor that does not include the SORA. However, due to the facts of these circumstances of this case, I have not been able to find one. I did email Mr. Tuttles on July 26th to indicate if there was a specific charge that he thought would fit the facts of this case that would allow us to plea that did not include SORA. I could take that to my supervisor, but as of right now, I don't believe that I could find one that would be appropriate. At this point, the plea offer still remains for an attempted CSC third.
The only option I think that the people may have that would better fit a possible plea would be assault as A and B. But if the people have not, the people are not prepared to make that offer, Your Honor, so we're headed to the trial docket.
Okay. Maybe that's where we are. Ms. Bruder, do we have a witness list? I know it would be easy if I had the file in front of me and I could just flip through it to see if we have one.
Your Honor, I have printed out one, but I did not check the box that I actually filed it yet. So I'm not 100% sure if it's been filed.
Okay.
I could file it by Tuesday or Wednesday of next week.
That would be fine.
Okay with the court.
Absolutely be fine. And when you file it, if you could also provide us with jury instructions for the particular offenses that are going through, and I can then fill out the appropriate form and put it in the trial queue and see what happens. But in the meantime, I can give us a date just to while that's going on, to make sure it doesn't languish there. And that would be a December 1st date. So Wednesday, December 1st. And do you know how many witnesses you would be calling? And-
Your Honor, the people have, I apologize, I don't mean to cut the court off.
No, it's fine. That's the way we talk. You can anticipate and you answer. That's fine.
3 to 4 witnesses, Your Honor, for the people.
And are there any stipulations that you're pretty sure that you will be asking Mr. Tuttles to accept?
I don't believe this case really has any stipulations, Your Honor. I
that's
think
good.
it's
I
just
don't-
a
I
matter
don't
of,
know. I'm just simply asking the questions. And Mr. Tuttles, how many witnesses?
2, Your Honor.
All right. When we got that, I'll await that. We have a date. I'll throw it in the queue and we'll see what comes up. Okay.
yes, Your Honor, thank you.
No, appreciate it. Thank you much for your help.
No problem. Have a great weekend, everyone. Be safe.
You do the same.
Okay.
Are we ready
Your Honor,
on? Yes.
I
Mr. Tuttles.
apologize.
It's
I
all right.
apologize, Your Honor. The December 1st date. I apologize, Your Honor. I have a question.
Yes.
The December 1 date, is that on A docket, B docket? Because everything was breaking up and I didn't
No,
get the docket or.
There is
that
no
just-
docket. That's in anticipation of the trial.
Okay.
If it's scheduled in person and we're back to some sort of normalcy, but I'm taking the case once I get this information and just sending it into the trial queue. So I know it won't be called, but at least you'll know that that's the next quote unquote action date, if you will. Okay.
Okay, thank you.
Thank you.
So you and your staff have a great weekend.
We're trying.
Okay.
Oh,
Judge Morrow, I don't mean.
Mr. Sullivan, so you're representing Moto G Play, huh?
Yes, Your Honor. I hope I didn't hold the court in suspense all this time.
You did. You know who I thought was going to appear? The figures on Madagascar.
Oh.
Well,
we're sorry to disappoint.
Are you not with the reference, Mr. Sullivan?
I'm missing the reference. I mean, I'm familiar with the movie, but
okay. So who was Gloria?
It's been a while.
Oh no, come on, yeah. Come on. Look at your phone. Google.
Can I phone a friend? I see Kim Michon may be able to help me out.
You can call a friend. You can use a friend line.
Okay. Bail me out,
Kim. Hippo. She was the hippo.
The hippo. Final answer.
Okay. And did you see Madagascar 2 by any chance? Back to Africa? No, that's Madagascar. I'm sorry. No. But anyway, remember when Gloria finally saw somebody that looked like her? And he wanted to be her beau. And his name was? You need to ask him. Mr. Sullivan,
I don't know.
You have flunked the class.
Yeah. I love the story that you're telling, though. I see the picture. I can't fill in the blank.
Mr. Dupree, can you help him out? He's already used one lifeline for Miss Michon. Can you help him out with Gloria's beau, what his name was?
Judge, I'm sorry to say that I've never actually seen Madagascar.
Oh, okay.
We have homework this weekend.
Where's your P number, man? I'm taking away your P number. You don't deserve a P number. Miss Elijah. Hold it. You don't have any answers either?
No help over here.
You should have Googled it and shot him a text. You can't leave him hanging like that.
I was considering it.
You do it, please.
I suppose I have Google too.
Yeah, you do, but I'm looking at you. You can't cheat while I'm looking at you. But they can help. They can help you. That's why they say put away your phones, put away all distractions.
Right.
Okay, Google Gloria's boyfriend in Madagascar.
Melman?
No, Melman was not. Melman was the giraffe, man.
Oh no.
Judge, in his defense, that is on Google. When you Google it,
Okay,
says-
but
it comes up.
Google boy. Yeah, because yeah, he was Gloria. Yeah, he was the original boyfriend, but he took a jealous little dive and tried to commit suicide and throw himself into the volcano.
Moto.
Thank you. And his famous line in the movie was, "I like them chunky." And
I'm gonna watch this movie tonight. This is gonna happen.
And that was his rap to Gloria. "Come here, girl. I like them chunky." And they did this little, she had finally found somebody that looked like her and he liked her. And you know, rhinos are what they are anyway. So
right.
he was giving her a compliment. And
I know, I appreciated the compliment.
Exactly. Anyway, man, that was like hard. We would have lost in that. What is it? What is it? We try to throw them clues and they try to guess. Charades. Yeah. We would have really gotten whooped in charades, man.
Yeah. I'll sharpen up. I'll be better next time.
You need to be, because I'm going to get a new partner.
Yeah.
I mean, yeah, for real.
Kim, you should, if I may make a nomination, I think Kim would be a great partner.
No,
she's trying her best to feed me answers, and I'm missing
right. You need definitely to go home and do some homework tonight. It should be on.
I'm going to reflect on all of my life choices tonight.
Yeah, but it's a good movie. Great popcorn kind of movie, date movie. If you need, just have somebody to help you through the movie. It moves quickly though.
Yeah. Is that Pixar? They usually.
Yeah, I think it is Pixar. Okay, well, can we get Moto to show himself?
Mr. Snipes, can you hear us? Dylan Snipes, Moto. There he is. You got to unmute yourself, sir.
Okay, this is people of the state of Michigan versus Mr. Snipes, 20-29-61. Your appearances for the record, please.
Good afternoon, Your Honor. Steve Lockfield for the people.
And good afternoon, Neighborhood Defender Service by Andrew Sullivan, P84261. On behalf of Mr. Snipes, who's here present by Zoom, we ask that you waive our appearance in person, allow us to proceed with sentencing by Zoom today. Mr. Snipes, can you introduce yourself to the court? Unmute yourself first. You got to push that microphone button, unmute yourself.
How many times has he heard?
There we go.
Dylan Snipes.
We got it.
Dylan Snipes.
All right. Go ahead, Mr. Sullivan, please.
Yes, Your Honor. We submitted a memo on sentencing. I just copied the state on that today, and I apologize for not including them in the initial submission. But we're requesting, if Your Honor would consider a short term of probation sentence on this case. I understand we've pled to 2 misdemeanors. And at this point, we are engaging Mr. Snipes with the reentry project through the Neighborhood Defender Service. We'll be able to help him be supplied with counseling and meet his other needs. And so we feel that probation would be an appropriate sentence, and we ask that Your Honor consider a short term of probation.
Mr. Lockviller, do you need time to review what was sent to you, or do you have an opinion?
Yeah, I did just get this afternoon. I've been going through it. I think I've read through it pretty well. So I can just move on to sentencing if you like.
Okay.
And these are misdemeanor charges. I believe there was an oversight on my part here with the obtaining a pistol without a license plea. I don't believe I'm not sure if it was part of the plea agreement or not. However, the typical plea would call for 1 year of probation, forfeiting the weapon, and no weapons during the probation period, which I believe the forfeiture of the weapon is mandatory under that statute. And I'm not so concerned with the amount of time for the probationary period, but I would ask the court to enforce or to sentence to forfeiture of the weapon and no weapons during probation as part of its term.
Absolutely. Young man, what would you like to say on your own behalf, Mr. Snipes?
Well, I understand that I did everything that was wrong. It was wrong. I should have had the weapon with me or whatnot. And I shouldn't have been driving. I understand that. Man, it's nothing else I can say. I was wrong. So,
Can you tell me the process that you mentally went through that made you decide that carrying a gun made sense?
Oh, yes. Well, I've been carjacked twice. I've been stabbed, almost died. And that's what made me start carrying a weapon. I just hadn't time to get my license because of the COVID.
Did you think that if you had had a gun in any of those instances, that the result would have been different?
No, because I would never have shot nobody anyway.
Okay, so then what is the point if you're not ready to shoot and kill somebody in getting a gun?
Right, exactly. I should never, like I said, I should never even.
No. I understand anger. I understand frustration. I understand the desire for protection. I understand every reason if somebody tells me why they get a gun. But my question always is, are you ready to kill somebody?
No.
Because that's what getting a gun preps you for.
Yes, exactly. That's what I understand right there. That's why I said, no, I shouldn't even had it with me because I know I wasn't going to even shoot nobody.
Right. And even having a gun, man, sometimes the criminal pop up on you so quickly, you couldn't even got to the gun in the first place.
Exactly. That's right, Your Honor. I hear you. I believe what you're saying. For real, 100.
Were you raised in a house with your father and your mother?
Yes, they just recently passed, both of them.
Okay. What did you all have in the back in the closet near the front door?
Well, my father had a 2-2 rifle.
Okay. My dad had a baseball bat.
Oh, no, we had a bat too.
Right. But they had,
yes, we had a bat.
Bats in the closet.
The gun in the closet, the bat was at the front door, yes.
Right, leaning right in the corner. So right next to the mail slot.
Yes.
You wasn't getting in that house without getting hit with that bat if you were the wrong person.
Right, exactly. That's true.
He just wanted to render them defenseless.
Yes.
My daddy didn't want to shoot nobody, but he was down for breaking a leg.
Exactly. Breaking some limbs. Like as you say, limbs.
Right, exactly. Plural.
Yes.
Right, and that's what people protected. They figured that once they got out the house, that they was good. So in navigating whatever situation, so they didn't have to take the bat out of the house.
Exactly. That's right. That's true. The same thing he said to me. Yes.
So maybe we should learn from those old school guys that you know, just protect the house. And ain't nobody gonna shoot anybody anyway coming in the house, because ain't nobody that crazy to come in the house while everybody is there.
Exactly.
So Mr. Sullivan wanted some time to get this memo together, because remember the last time we were here, I said, Snipes,
Yeah.
he tried to protect you. Do you want him to protect you?
Yes.
And so Mr. Sullivan wanted to be your weapon.
Right. He is my weapon.
Okay, and he ain't loaded.
Nope, not at all.
Right. You know what Ice Cube said, that his lethal weapon was his mind.
Right.
And that's
right.
what Mr. Sullivan wanted to be. He wanted to be your lethal weapon.
Exactly.
So did he misfire or did he shoot straight and clear?
Hopefully he shoot clear to you with the paperwork that you asked to send to you.
No, he misfired, man.
Oh, wow.
No, I'm just kidding. He didn't misfire.
Okay.
He got one round off in the right direction.
Hello. That's good. I thank you, my lawyer. Yes.
All right. So what can I expect from you, seriously, Mr. Snipes, in terms of thought and in terms of behavior and this whole process? What can I expect?
I learned from my mistakes, and it taught me very well. And like I said, I'm not drinking. I'm not drinking anymore. Or nothing. Like I said, I lost my mother and my father. When I lost my father, I was drinking. And then when my mother went into COVID, and I say, okay, now I've been going to court, you know, so I'm good. I'll learn my lesson.
All right, this is what I need you to do for me.
Mm-hmm.
I need you to do grief counseling for me.
Okay.
And that's it.
Okay, I will do that.
And unfortunately, I had to charge you a few dollars for the cost of the conviction and it's like, Mark, does he get charged separately because they're two misdemeanors?
Yeah, it'd be $75 crime victim and then $53 twice because there's two counts. So that's $106 for 181 total.
So, Mr. Snipes, you pay that $181 and do that grief counseling, and then that's it. That's all I want.
Okay, I can do that. Now, when do I have to pay that? Can I pay it today?
I'm gonna give you 6 months to do everything, and as soon as you finish, I'm gonna close probation.
Okay.
So yeah, you can pay the money.
I can do that. Oh, excuse me, I'm sorry. I can do that before six months.
Right. Now, the place that I like is a place called St. John's Open Arms. They do real good grief counseling. I'm not sure if they're back in person or not, but it's like 8 Thursdays in a row.
Okay, that's fine.
But
that's fine.
I think you'll benefit from that.
Okay.
So that's it.
All right. Thank you, Your Honor.
Thank you, Moto. Did you
Your
see?
Honor, just
yes. Oh, and yeah,
Can I
forfeit the gun. Thank you. Forfeit the gun and can't have any guns.
No more.
Period.
Oh, you're on probation.
Okay. Why I'm on probation?
Right.
Okay.
Thank you, Judge.
Thank you. I forgot about that, Mr. Knox.
Thank you, Your Honor.
All right. See you later, sir.
See you later, too.
Thank you very much, Judge.
Pleasure's mine.
We'll see you next time. You all have a good weekend.
Thank you. Let me know about the movie, man.
I'm gonna watch it this weekend.
Yeah, let me know next
I'm gonna
week.
see you. I hope to see you at the
You said
Charles Wright
tonight.
Center this weekend. Maybe
You
I'll
hope-
have an update about my
you hope
movie
to see-
status.
See me where?
At the Charles Wright Center, right?
Right. Well, that's where I'm gonna be, and maybe Saturday I might be at Beacon Park and a little bit over at the other place. I like to get around on the weekends. If you my
Right
age,
on.
you know, grass will grow under your behind if you sit down too long.
Yes.
So I try to get up and out there while I can. All right.
Well, I'm grateful for the recommendations.
Thank you. Let's go to Dewan Peoples. Let's keep moving. I don't know what you have, Miss Michonne and Dupree, but I know Peoples is with Miss Elijah. This is case number 188364. Deshaun Antoine Peoples.
Good afternoon, Your Honor. Steve Lockbeeler for the people.
Emily Elijah, NDS P85039 on behalf of Mr. Dewan Peoples. And Your Honor, Mr. Peoples is in custody. I do see a Peoples in the here now, and it's because some people are watching on YouTube and some are watching in court today. But Mr. Peoples is in Division 1.
And Division 1 didn't give me his name, I don't believe.
No, Your Honor, I'm not sure if they did, but he was on the calendar today for this docket.
I see. Okay, so we'll have to find Mr. Peoples, and if he's in custody, our next in custody day is the 31st of August.
And Your Honor,
Can we do anything without his presence in terms of non-substantial? Do we need to put an offer on the table? Do we need to discuss anything that is just administrative?
So I did submit a motion to modify the conditions of his release, Your Honor. I know he's been eagerly awaiting that. I've spoken with his family about that. I only filed it a couple days ago. So if we could waive his presence and address that. I'd also like to address discovery if this court is amenable for that.
Mark, I don't have anything as it relates to Mr. Peoples.
He was definitely on the list today. I
Yep,
think
he
maybe,
was.
you know, the jail's got 3 other courtrooms they got to deal with.
Can you print
So-
out? Can you please print out what Miss Elijah had sent to us, please?
Did she send it to me?
I did not email it. I only filed it, and maybe in the future, sounds like in the future, I need to email these as well.
No, if you e-filed it, we get notice, and I usually send the notice or it gets filed to Mr. Ulatowski.
Judge, wasn't that the double-sided motion?
I will look up on my desk real quickly, but I don't remember seeing the name Peoples.
I am happy to make an oral motion, Your Honor. The motion itself,
Doesn't help me, doesn't help me. I don't need an oral motion. It doesn't help me. I need to read something. Ms. Michon, what is your matter? Mr. Dupree, what is your matter?
Judge, I have Mr. Yospan.
Ah, yes. Yes, thank you. Let me do that one. Since that doesn't require anything other than us placing it on the record. And thank you. Let me
And
find.
Judge, just to answer your question, I have Amir White, who's also in the jail.
Okay, Ms. Wilmoth, are you with us?
I'm here, Judge. Good afternoon.
Good afternoon. This is case number 20-0767. Brian, B-R-Y-A-N, Yosban, Y-O-S-B-A-N, Ms. Smith. All right. Young lady.
Judge, this isn't on our docket.
Yes, it is, Mark. It's an emergency one. They sent letters, emails to Prentice, to me, to docket people downstairs, and it was told.
So they told everybody but the person that does the scheduling. Okay. What's the case number again?
It is 20-0767. And it was sent to the criminal daily docket to Prentice, and they were told it has been scheduled per your request. Need immediate assistance. People be Brian Yospan. Okay, so Ms. Wilmoth, what I understand is you need me to issue a capias on the record. Is that correct?
That is what the court is that is what the people are requesting at this time, Judge, as stated in our motion.
I just wanted to just cut to the bottom line. And
yes,
so
that's the bottom line. The people are requesting a KPS.
okay, so that's what we need to do. And Ms. Michelle?
I would like to respond to that, Judge. The motion is for a capias for failure to appear in court. Mr. Yospan has not failed to appear in court. He's been in federal custody the entire time. He is scheduled to be deported again. And so what the government is asking you to do is to now interfere with the extradition or the deportation of Mr. Yospan back to Guatemala. He has never failed to appear. He has always been in federal custody, except for the moment that he was deported the first time. We've always known, and we put it on the record last time, he has always been in federal custody. I've looked at the statute, Judge. I don't see a administrative easy way, right, to get him here. But to capias him, every prosecutor on the planet in the future is going to look at his failure to appear and a capias was issued. Then, God forbid, the next time we have to argue the bond. So as long as prosecution never wants to argue that a capias means he doesn't show up for court, because we know where he was. He was in federal custody. To now issue, that is true.
Your Honor, that is not true. That is not true.
I'm sorry. I'll rephrase. Nobody bothered to look where the man was. And we've now substantially understood he's been in federal custody this entire time. He had an ICE hold and prosecution never bothered to figure out what facility he was in. And to now issue a bench warrant for failure to appear because you lost him, that's not appropriate. And I don't believe,
Judge,
excuse me, then you could do so in just a hot second. But to issue a warrant for this man who has been constantly in the property of the US government versus in the Wayne County jail, all you're gonna do is haul him back here, stick him in the Wayne County jail where he's gonna sit for another 2 years before we go to trial on this thing. And this is the true issue is, if the complaining witness is believed, this young man asked her father for her hand in marriage, and they are alleged to have had sex underage. And this is what we're going to pay to have this man extradited from Texas, sitting in the Wayne County jail for 2 years because he fell in love with somebody slightly too young in this state, as opposed to any other state. And so the next time Kim Worthy hops on, stands out there and says, I don't have the money to prosecute all these cases, maybe we need to look at what cases we're prosecuting. But I don't think this court has the authority to issue a bench warrant for a man we know where he is, let alone backdate it to the 3 times the state government lost him or didn't know which facility he was in. That is not appropriate. There is no administrative, let's make it easy on everybody to get this man here. I don't see that exception in the statute.
Ms. Wilmoth?
Judge, I would like to respond to a couple things here.
Go ahead,
First and
please.
foremost, Ms. Michonne's view of the case, that can be her own personal view. But what we have is a 14-year-old allegations that a 18-year-old defendant engaged in sexual intercourse with her, resulting in a pregnancy. The law is the law. Okay, that is, I'm not even going to get into the allegations of the case because quite frankly, you've read the preliminary exam transcript.
I have.
That being said, this situation is not any different than any other capias situation when parties appear, including defense counsel, and the defendant is not here and no one knows where he's at, right? the defendant could be in custody in the jurisdiction of California, could be in federal custody, could be in the hospital, could very well be deceased. It is not the people's responsibility to track down every defendant who capiouses from court, because what happens when we find that person? Well, there's no capious warrant in the system, so there's nothing we can do about it anyway. Law enforcement can't pick that person up when they are located. I certainly can't go just cruise down wherever the defendant is located and hold them to court. The bottom line is the people do not have that authority. They don't have the authority to order a defendant to court. It has never been the responsibility of the people of the state of Michigan to keep track of every single defendant accused of a crime. That argument to me is absurd. And quite frankly, I would think defense counsel as an officer of the court would want her client to be in court, to have his day in court to answer to these allegations. The bottom line is Mr. Yosban failed to appear in court on 3 occasions. Now, just because I subsequently located him, that does not change the fact that he failed to appear. The sole power and authority to order a defendant to come to court is with the court. That is a power delegated to the court, not to the people of the state of Michigan.
Response, Judge?
Go ahead, please.
Judge, on every single court appearance we can track, he has been in federal custody. Between 2 court proceedings, he was deported, came back, he's now back in federal custody. Each time we appeared, he was in federal custody on an ICE hold. We all knew it. We just didn't know what facility. To now issue a bench warrant for failure to appear is abhorrent. And there has to be a better way.
Okay.
Well, Judge, can I just say one last thing?
Thank you. I've heard you. Heard.
I called courtroom.
Thank you, Gregory. Mute yourself. So the question becomes, when a person is on bond and fails to report to come to court, what is the appropriate thing to do? Is it to issue a bench warrant or a capious? And how about when a person is in custody and we fail to bring them, or an extradition warrant isn't provided? Is the remedy to provide the same response? Issue a capious for a person that's in a different status. So that's the real question. Should you do the same thing when it's the government that has the possession of the person, and the government or the prosecution, because sometimes the prosecution has to extradite people or start the process. Like if we know that they're in custody in Monroe, we get a writ to bring them from Monroe to here. We don't issue a capious because they're not here. Issuing a capious, I believe, is the proper response for a person who has control of themselves when they fail to appear. You don't think that that's true, Ms. Wilmer?
I disagree. I disagree, and here's why. He cannot be extradited without some type of warrant, active warrant in the system. He has already been arraigned on the charges. He cannot be extradited because of just a pending felony case.
I know.
And here's my other problem.
I have had prosecutors extradite somebody from a federal penitentiary when we had a pending case and they were in federal custody. I know we brought them back without a capious, without a warrant.
If I could show the court the massive amount of emails with the U.S. Marshals, with the APA that handles extraditions, I can assure you that that is the information we have been provided. But the court brings up a good point when we're looking also at the fact that Mr. Yosban has a pending felony case, and an inherent condition of bond would be to not engage in any further criminal activity. Well, illegally entering the United States is a federal felony. So then again, We also have a violation of bond.
He's
And you can
not
look at
on, no, he's never been on bond.
on this case,
Yes. He's always been in custody. He's never been on bond.
but he has a bond.
No. He's never been on bond to violate bond. You can't violate something you haven't been on. So no, he hasn't violated bond, a bond that he never had. And that.
Well, he was free. He was free to come back into the country illegally.
Well, I don't know. Okay, so I'm reading, you're saying an active capias warrant would be the easiest way to secure. Okay, what's the hardest way to secure? Because a capias in my mind is something that is issued when a person voluntarily chooses not to appear in court who has been on bond, and it is their decision to not make themselves available. It is not when they have never been in custody and the government continues, the government forces, the state, the local, and the federal haven't been, I mean, it's confusing. But I'm not prepared to do that yet. I need to see.
Well, if I can address your question, subsequent to filing that motion, my first avenue was going to be to ask the court to sign a writ, which I did provide to Mark. However, subsequent to filing that motion, I have learned that because the defendant is out of state, that a writ will not effectuate or allow the people to start the extradition process.
You can't start extradition with a writ.
I have been informed by the APA that handles extraditions, because quite frankly, I had to learn a lot about this as I went. It's not my area of expertise per se. I have been told that extradition is unlikely to be able to be effectuated with a writ. Now, if he was in custody in the state of Michigan, a writ would certainly suffice. The problem is he's in U.S. Marshal custody, set to be then released to ICE. There's all these different entities involved. And we have no authority to do anything with him.
Well, Ms. Michon says that I would be misusing my authority and acting illegally by issuing a capias for a person who was not on bond, for the government's responsibility and the court's responsibility to keep track of a person that's in custody. It is not the defense's responsibility. I see that as my responsibility, your responsibility, and the people who are charged with keeping him in custody, our responsibility. It is not on Mr. Yosman to make himself appear when he has nothing to do with his custodial status. But I'm not sure that using a capias, if you all can give me some law, I'll be happy to follow the law on the law of capias and what should and when it should and should not be used. I'll be happy to respond as quickly as possible. But it causes me some pause right now without further research if that is the legal use of a capias. I don't know. So I'll be happy to get some more information. You want to get back with me next week? 8. Today is 8:20. Next time I'll be in custody is 8:31. Or 8:30, Monday or Tuesday next week.
Judge,
So,
does
Your
it have to be
Honor,
on?
if-
I mean, the
ahead.
following week. I'm sorry, not next week, but the following week.
So if my motion is being denied, can I kindly get a written
It's
copy
not-
of that order?
It is not being denied. It is being continued so that I can get more information on whether it should be denied or not.
Well, then, yeah, we're gonna be in a pickle anyway, so that's why I need to
I'm-
emergently get in touch with appeals, because he will be gone. August 25th, he will be gone. And he will not have to answer to these allegations.
My point
The
is,
bottom
I
line
don't-
is he failed to appear, Judge. He failed to appear 3 times,
it's not that I haven't.
whether it was
heard your
willing or
argument.
unwilling.
Why are you raising your voice? I don't think that that's necessary. I'm trying to explain it and you keep on talking over me and you're repeating and saying the same thing. What I am saying for the last time is that I don't have enough information on whether to deny or grant your motion. And I am asking for further research so that I can follow the law. And I'm giving you 2 dates in which you can provide that information to me so I can make a decision on whether to grant or to deny it. And that is 8:30 or 8:31, whatever's best for you all. Those are the
Judge, what-
next dates that I will be here. On 8:30, I'll be in person, and 8:31, I'll be on a jail docket.
Judge, we're already on your docket for the 30th.
Okay, well then, I'll look for those memorandums, and I'll be prepared to hear whatever argument exists, or if the law is real clear for stipulations, or I'll make a decision, whatever. So I'll see you all back on the 30th then.
Thank you, Judge.
Thank you.
Thank you.
Mm-hmm. All right. Man, Ms. Cal, thank you for your patience. Mr. Pincata, are you ready to do what we need to do with Mr. Pincata? And is the capo on for Mr. Pincata? I see you, Gregory Pincata.
Yes, hi, Judge. How are you?
I'm good, thank you. This is the people of the state of Michigan versus Mr. Pincata on one case 21-2835, and Gregory Pincata for violation of probation, which is pending. But it's just that the warrant is out there on 19-86-17. Your appearances, please.
Good afternoon, Judge Morrow. Richard Floyd on behalf of the Probation Department.
Wanda Kell on behalf of Mr. Pincava.
All right.
Your Honor.
Gregory Michael Pincava.
Yes, thank you, Mr. Pincava. What are we doing on your case with him, Ms. Cal, on the active case?
Your Honor, you had instructed the prosecutor to explain to you why it took over a year to bring this warrant in. Mr. Pincava had a global resolution of a number of cases prior to me being involved. And during that time, they did not resolve this case, allegedly. Mr. Pincava said they did resolve a case, and you had tasked the prosecutor with finding out what happened with this case.
Thank you. What'd you find out, Mr. Floyd? And who was our prosecutor? Mr. Lockbiller, is that you on the new case?
Shouldn't be. I'm checking right now, Your Honor.
Okay, so what did you find out, Mr. Floyd?
Your Honor, I'm just finding out that he had this this new case today. When Mark informed me of this new case.
Okay. Mark, can I see the new case? This case was not listed on his last pre-sentence report. Is that correct, Mr. Floyd?
Yeah,
as a pending case or anything of that nature?
Yeah, I would have to look at the pre-census report to see if it's listed as a pending case.
Would you please?
Yeah, I'll look at that.
Hi, Wanda Kale. How are you?
So, Mr. Floyd, the date of offense for this 21 case is March the 19th of 2019.
Okay. Let's see. The last pre-census report, I got census date 12/13/2019.
And that would have been 6, 7 months, 9 months after the date of this offense. And
I do see a pending charge of concealed stolen property out the 20th District Court and felony organized on the 33rd District Court. So I don't know.
Juice in my phone.
I don't know which
Gotta try to get over here and get
this
some
district
juice.
court carried over this, bonded over this case. So on the new case, he's been charged with retail fraud, first degree, and receiving stolen property, motor vehicle.
Yes. I texted him on the thing. He texted back on us. What's your phone? I said, man, look, I'm gonna get another lawyer.
Mr. Lockviller, when was the warrant signed on this case?
They've notified the prosecutor on the case. He'll be jumping on in a minute.
Mr. Dupree, what case do you have, sir? Again.
Your Honor, I have Amir White. He is in custody, but obviously was not brought today.
Man, you are long suffering. This is a case that was supposed to be blind drawn to Judge Bill. Is that right, Mark?
It's off of Judge Bill's docket, and we were supposed to blind draw it, but I guess if we don't have Mr. White, I can put it back on to Judge Bill's docket.
Okay, can you do that, please?
Yep, let me find out what his next in custody date is before the attorney leaves.
Judge, I do think I would say if blind drawing is an option, I would be fine with that too, whatever is of greater convenience to the court. I
Yeah,
don't,
well, the only thing is we need him to hear so that he can say he waives a formal reading of the information. Or you can
That
do
makes
that.
sense.
You want to waive his presence and then we'll blind draw it?
I'd be happy to do that, Judge.
Okay, this is case number 21-5499. Amiri Rashard White, your appearances, please.
Good afternoon, Your Honor. Steve Lockville for the people.
Good afternoon, Your Honor. May it please the court, Matthew Dupree, P8132, attorney for Mr. White, whose presence I'd ask the court to waive.
Okay, I'll waive his presence, sir. Scheduled for an arraignment on the information.
Your Honor, we would waive reading, stand mute, and request a blind draw.
Okay, I will enter a plea of not guilty, and Mark, we will blind draw the matter to who and what next date?
Finding a case.
Hey, Mr. Ryan Kuski, how are you, sir?
Good. How are you, Your Honor?
What happened to your face?
got in a fight with a razor. It's a little hot for it these days, so I
Yeah.
thought I'd switch it up.
Oh, you did, and you're recognizable either way. How about that?
Thank you, Your Honor.
Just wanted to make sure you weren't trying to avoid detection.
No. I'm here. I apologize. I didn't have it on my calendar. I heard Mr. Pincava is up.
Right. We were wondering that the date for this case is 3/19/2019. That's the date of occurrence. He was sentenced on the case that he's on probation on December of 2019.
So Judge Moore, let me interrupt you for a second. So I'm looking at the pre-sentence report, And under this docket, the 19008617, it is, if this is through Woodhaven Police Department, because you said it was 3/14/19 offense date.
Yes, but this says Dearborn Police.
Okay, all right, because this one is saying there was this particular charge through Woodhaven, it was dismissed as part of the plea agreement on this case. Organized retail fraud. So that's not the same case we're talking about?
No, this one here says this is a Dearborn Police case.
Dearborn Police, okay.
Right. I know there was contact because the person who signed this warrant, which was not me, was wondering because of the volume of cases if this case was adjudicated previously, and it was not after their investigation. So yes, that's all I could say about it.
Yes, but the authorization of the complaint, according to the Registry of Actions, occurred 18 months later. It says the original charge, stolen property, the warrant was authorized September the 8th, 2020. So 16 months after the crime.
Mm-hmm. Yeah, that I'm not disputing, Your Honor. I'm just saying it wasn't previously dismissed. That was the only point of my comments.
Right. Well, what we were wondering was, shouldn't it have been dismissed? And why did it take, okay, from the authorization of the complaint is 9/8/2020. The complaint was issued February of 2021. So it was issued 2 years after the crime. And at first we talked about who sat on it. And it seemed like Dearborn sat on it for, well, from 3/13/19 to 9/8/20. Dearborn sat on it for 16 months.
I do remember us having that discussion now. That
right. And then from the time that the complaint was authorized, Wayne County sat on it for another 5 months.
Yes, and that's what I was, I guess, afraid to blame someone else with regard to that, because I didn't. Yeah, so it looks like he was the victim of a double sit. Your Honor, I think is Mr. Dupree Mr. Pinkava's attorney?
No, it's Miss Cal.
Oh, Miss Cal. I apologize, Miss Cal. I know Miss Cal well. My only concern is that the actual victim in the case is not penalized. So I could propose to Miss Cal, and I know she would probably have to go into a breakout room, or I could email her and maybe put it to another date, even early next week would be fine, is just get the restitution amount, add the order to any current probation Mr. Pinkava is serving, and do a dismissal, if that sounds fair to Ms. Cal, and if the court would accept something like that.
That sounds like an excellent way to resolve it.
Well, I appreciate that. Thank you, Your Honor. It's been a little hectic around here. I'm sorry I'm logging in so late.
Yeah, I don't think there's any restitution. It was about some equipment at Home Depot that they arrested him right there.
But he needs to check that, ma'am. That's
Yeah,
all.
if I could just check it out, Ms. Cal. Thank you.
All right.
Do you want to set aside the warrant on the VOP case, Jim?
I didn't think that I had signed it. Did I sign it? Know that he asked, you know, and
August the 7th.
Okay, yeah, I'm gonna set that aside because Mr. Pinkava's back. I thought that I had done that because Mr. Floyd and I had talked about he had reappeared and he had called the probation department and tried to. Mr. Pinkava's a busy kind of guy with everything happening all at once.
Well, yeah, the probation officer had asked me about him appearing for a VOP, and I told him you hadn't signed it yet. But then he contacted me and said that the warrant was signed on 8/9, I do believe.
Yep, which was, something that I just didn't realize because I didn't know that I had signed it.
Hey, Judge, I'm here on Martel Briscoe. Defense counsel is here too. It was set for your regular
Yes.
docket, not docket C.
Well, okay, and I'll get with you all. I see Martell. I know I need to just tell you what I decided to yay or nay his motion. I got you. For a new trial, and I know what I'm gonna do. I'm gonna deny the motion. So I'll let you all know that in 2 seconds when I just finish with trying to figure out the next date for Mr. Pinkava. So this is what I have. I have Monday the 23rd, which is a crazy day. I have 8:30 and 8:31. So my next days on are August the 23rd, 30th, and 31st. What suits you all the best?
The 23rd is bad for me. The 30th or 31st, I would prefer. And I would let Ms. Kell, if she has any
Yeah.
preference.
Your Honor, what time on the 31st? I have an in-person exam at 3:30.
I had an in-person exam at 3:30.
Bless your soul. Okay, I'll tell you in 2 seconds. 31st.
That's the B
is
docket.
docket B in the morning, 9 o'clock.
Can we go into October, please? I'll be juggling too much stuff on the 31st.
October?
Me too. Can we go to
September,
October?
I'm sorry, September. I'm sorry,
Okay,
September.
September the 8th then on docket D.
September the 8th. Oh, that's a perfect day, September the 8th, docket D.
Okay, so
Thank you.
for day, September 8th, docket D.
Good for me too. Thank you, Your Honor.
Thank you, Your Honor. Have a
And
great day.
Your Honor, oh, Ms. Cal, can you hold on? Your Honor, the mechanism for this, could I write up a proposed amendment to the probation, or how do you think?
To the proposed amendment to the.
No, you would just-
Technically, what would the easiest thing to be?
You would just make an oral motion and I would ask Ms. Kell to represent him on that case and she would be assigned and she would either object or have no objection and then and if it's a part of your reason for dismissing the case, I'm sure
Part of your
it
reason for
wouldn't be
dismissing the
objected.
case, yeah, sure, it wouldn't be objected to.
Okay, and does that work for you too, Agent Floyd?
Your Honor, for the probation violation, can we just continue the probation?
Yes, sir, absolutely.
Okay.
Oh, and maybe we could
Sure.
do that amendment to that when okay. Thank you. I appreciate your time, Judge Morrow.
And
No problem.
Your Honor, is docket D a morning docket or afternoon docket?
Yeah.
Docket D is an afternoon docket. A and B in the morning, C
Okay.
and D in the afternoon.
Thank you, Your Honor.
Pleasure's mine.
Have a great day, a great
Thank you.
weekend.
You too.
Thank you, Your Honor.
All right. Mark,
Judge-
Mr. Dupree is still
Judge-
waiting for a date. I got you, Mr. Dupree. You're still waiting
you.
for the date.
Judge, I need the address. I need a current address because the defendant was listed as
Okay,
being homeless.
Mr. Pincata, hang tight. Don't hang up yet.
Homeless on this, the last
okay.
warrant. So we need a current address for him.
Okay, I got you. Mark, our blind draw for Mr. White is what and where, please?
It's Judge Miriam Bazzi, and that'll be on September the 8th. And that is that'll be the C docket.
All right, so Mr. Dupree, when we're in person, you need to come by. I'll give you some free coffee and a Jolly Rancher for your patience. And we'll talk movies. We'll talk Madagascar.
I'll be sure to watch it, Judge. What was that date and time? I think I actually missed it. I cut out for a second.
Judge Bazzi is the judge. And what date again, please, Mark?
Get up again. September the 8th, C docket.
Thank you, Your Honor. Thank you, Mr. Clerk. Have a very nice day, both of you. Very good weekend.
Likewise. Okay. We're cooking almost. Mr. Peoples, what did we decide to do, Miss Elijah?
Your Honor, I would like to waive his presence and still argue for his release. His family has been patiently waiting. Mr. Artiz Peoples is here. He's his grandfather. And I know his older sister Alanya is on YouTube and has been watching, and I confirm she's still watching and waiting for this court's order on Mr. Peoples' case.
Okay.
Are we gonna recall the case, Judge, or just?
No, in a second. Let's do Theodore Turner. Mr. Turner, show me yourself and Mr. Glenn. And Mark, can you print out what has been provided on Mr. Peoples' case, please? What has been filed for me so I can read that. This is the people of the state of Michigan versus Mr. Theodore Wayne Turner. This is 21-1785. Your appearances, please.
Luther Glenn appearing on behalf of Mr. Turner, P 38683.
Yeah, for Mr. Turner.
Who is our prosecutor on Theodore Turner?
I believe it's Wilma.
She was on, Judge. Is not apparently now. I'll send her an email.
Thank you.
So
Okay.
she's not on, but when she's done, she'll be back on.
Okay. Well, we all almost need to go to the bathroom. Almost. Okay, Gregory. Mr. Pincaba.
Yeah, sorry, Judge, I had to unmute. How are you?
That's all right. Can you give Mr. Floyd your phone number now, please?
Yes, sir. 734-897-7319.
Where you currently living at?
I'm sorry?
What's
Where
that?
you currently
What's
living
your current address?
16523 Gate House, Gate House, one word. Woodhaven, Michigan. 48183.
at? Thank you.
Okay, Gregory, I'll see you later. Okay, Ms. Smith.
Thank you, Judge.
Okay, we are working our way through it slowly. All right. I saw Miss Wilmoth should be in, and we can do Mr. Turner, and then we'll do the Mr. Peoples case. So, Miss Wilmoth, this is the people of the state of Michigan versus Turner Theodore Wayne. This is case number 21-1785. Your appearances, please.
Good afternoon, Your Honor. Erin Wilmoth, P82085, appearing on behalf of the people.
Luther Glenn, P38683, appearing on behalf of Mr. Turner.
Okay, I have it listed as a final conference. If you could place the last offer on the record and let me know what your client wishes to do with that offer, please.
Yes, Your Honor, the people did communicate by email to Mr. Glenn their offer in the case. The offer that was presented was in exchange for a plea to count 1, criminal sexual conduct in the 2nd degree under the relationship section of that statute. The people would agree to dismiss count 2 with a sentence agreement of 2 years probation, SORA requirements, and no contact with the complaining witness.
Judge, I don't think Miss Smith is back.
Yes, she is. She's back.
Oh,
Thank you, Mark. No, I appreciate it, Mark. As much people to check, we'll make sure we're right. I appreciate that. Thank you. She's there.
no, the court picture is over her picture. I didn't see it. So.
Okay, no problem, but I appreciate it, man. You're looking out for me. I appreciate that. Mr. Glenn, what's your pleasure, sir?
Well, Your Honor, there are a couple of things that are going on here. So with respect to the offer, my client rejects that offer.
Great, okay.
And he sent me a text just a few minutes ago saying that he wants another lawyer. Now, I don't want to speak for him. He can speak for himself.
Mr. Turner, what do you want to say, sir? I can't hear you. No, I can't hear you. You have to unmute.
Respectfully, Your Honor, I don't believe personally I'm guilty of these charges. This is a huge misunderstanding that has been taken beyond proportions of tax dollars being wasted. I don't believe I'm guilty of this because in light of the way this whole thing is going, and I'm emotional right now, forgive me, Your Honor. In light of the way this whole thing is going, it's totally unnecessary. First of all, this could have been handled within my family. There's some things going on within my family.
Mr. Turner.
Yes.
Got to concentrate with me, please, on your relationship with Mr. Glenn. And he says you've rejected the offer, so the only option you have is to go to trial.
Okay. And the reason being because I'd rather fall under the hands of God and allow whatever comes down to me. I'm not running from anything that I've done. And I confess everything that I have done that was illegal, which in this case is nothing. But in regards to Mr. Glenn, I've been reaching out to Mr. Glenn to contact me to try to get me to understand what's going on with this case. I have gotten no responses. I just got this email to this court date at 2:39 p.m. today on my way to work. So I had to finagle and find a way just to scramble to get this because my phone was dead. So I've been scrambling around just to get into the court today, Your Honor. He hasn't responded to any of my emails, none of them. And I don't know what's going on with the case personally. I don't even know what's happening.
Okay, Mr. Turner, can you give me your phone number, please?
Yes, sir. It's 313-854-8152.
8152?
Yes, sir.
I will grant your request, Mr. Glenn. I will thank you and excuse you. Do you know how to log into my personal docket, Mr. Turner?
No, sir.
No.
Okay. What I'm going to do is I'm going to utilize the appointment of counsel form, and another lawyer will reach out to you, Mr. Turner, and we'll just schedule October the 4th as your next day due. But somebody will reach out to Mr. Turner, just give him a call back. They'll say that they were appointed by the appointment of counsel people, and we'll do it that way.
Yes, sir.
Okay. Thank you. That's
Judge,
October.
there's a little background noise. I'm not sure I got the date.
October the 1st, and I don't know where the background is coming from either.
Okay, October the 1st on your regular docket.
Yes.
Great, thank you.
Thank you. All right, Mr. Turner, somebody will reach out to you. Thank you, Mr. Glenn.
Thank you, sir.
Okay.
Everyone enjoy the weekend.
Yep, we are trying, that's for sure. Okay, on the Martell Briscoe matter, 196596. Your appearances, please.
Mary Casey Cretu, P72485, on behalf of the people.
Good afternoon, Your Honor. Jonathan Simon, P355964, for Mr. Briscoe. Your Honor, Mr. Briscoe is in the custody of the Michigan Department of Corrections. I would waive his appearance.
Okay. Is there any objection by the people?
No objection, Your Honor.
Okay. This motion having been filed, a hearing having been held, I am going to deny Mr. Briscoe's motion, and we'll sign an order doing that and supply it to all counsel. And I appreciate your patience. Man, what a crazy day. And for the couple times of trying to have him here and him not being here. But thank you all. Have a great weekend. Now we're back with the people of the state of Michigan versus Dewan Peoples. So, Mr. Lockbiller, you got a copy of that? Did you not?
Yes, I did.
Okay. And you want to waive his presence, Ms. Elijah?
I do, Your Honor, and reason I want to do that is because he was not brought over by the jail today, even though he's in custody and he was on the calendar. And I am asking that the court consider alternative conditions of release,
Like what?
tether, house arrest, or any bond that he could potentially make with a 10%.
Can you explain the relationship between a tether and somebody coming to court?
Well, tether reminds people that they have court. It's a constant monitoring that they have the device on them.
And you think your client needs reminding?
Well, I don't think he does now, Your Honor. He's been in jail for over 30 days. Also, the people who are supporting him are here. I'd like to thank Mr. Peoples, his grandfather, for being here all afternoon. I've also spoken to his older sisters who are willing to help have him live with them and be responsible members of the community, monitoring him and vouching for him.
Okay, so where was your client for 2.5 years?
He was not in court, Your Honor.
No, where was he was my question. I know where he wasn't.
Oh, he was in Detroit, Your Honor.
Who was he living with? Was he living with the same family members?
I'm not sure, Your Honor.
Well, I'm asking you.
I know. I really wish Mr. Peoples was here to talk with the court, but it's not his fault that he wasn't brought over by the jail.
Well, we can, like I told you, we can make provisions and have this the next time that I'm on, and that'll be docket B on 8/31. Because if you're arguing for bond for a man who has been in the city of Detroit, knowing that he had a case, and every day for over 2 years didn't do anything about it until he was arrested, and now he's crying that he's been in custody and oh, poor me. And is offering the same people as a support system who have been there the entire 2-year period of time. That's not a very persuasive argument.
And Your Honor, I do know that Mr. Peoples had written something not written physically, but had written something down after we had talked about it, so that he wanted to share with the court. And he's only 22 years old right now. And the problem is that I now have his case. It was set for trial, and we're in the middle of COVID, and who knows when he will get to a jury trial. I haven't received discovery yet, which again, not again, but.
Well, he missed the jury trial right before COVID.
I know, Judge.
And so, to me, every day you don't turn yourself in. So in my mind, he's had over 700 opportunities to turn himself in. 700. 700.
I know. I think what we're asking for is a little grace on this. This is a B&E.
No. You're asking me to do something that there is no reason. It's a little beyond grace, seriously, because you're not offering me anything that can be substantiated or that would signify responsibility. You're not offering me, Judge, the man has voted in the last 4 elections since he hasn't shown up. Or Judge, he's held steady employment and these are his paychecks. See, he's responsible and reliable. Or Judge, he had a child and look, he's made all these child payments through the court. So look at how responsible he's been acting. You're just like, oh, same family, same support group. Now all of a sudden 30 days is such a big deal when his issue would have been solved had he shown up for court. And without anything that would document and that you can verify that shows maturity from that date to this date, then that's not a very good argument, Ms. Elijah. That's not a convincing argument. To say it's not a good one is a judgment. And so let me take that back. It's not a strong argument. It's just saying, do him a favor because you can do him a favor. And he was given a favor when he was out on bond.
You know, I understand the court's frustration.
No, I'm not frustrated. No, I'm just saying, you haven't shown me anything that would be convincing. And it's probably because there is nothing.
I have a few things I could talk to the court about.
Okay, has he voted in the last elections in the last 2.5 years?
I did not ask him about voting, but when I did speak to him and talk to his sister, he has taken steps to get his driver's license. So
Okay,
he's
I don't know what taking steps means after 2 years.
he took his driver's test recently. He also has been working with his sister to get his GED. So he got the books for the GED course, and they were, he's going to sign up for that GED course. That's something that I spoke with Ms. Alanya Peoples about, and that's an older sister of his.
Well, I'm sure all of these people knew that he had a case pending and that he didn't resolve it. How come they didn't call the police and have him turned in? Now, I know that that's a rhetorical and stupid question because I wouldn't call the police either. But at the same point, they are harboring a known absconder, right? The answer is yes. They knew that if he didn't come to court and they still had, but I wouldn't have called the police. Come on, the police? That wouldn't have ended well or had a potential not to end well. But the same community that let him live for 2.5 years is the one he wants to go back to. He hasn't done anything in the last 2 years to merit consideration. And that's just the truth, Ms. Elijah. The truth sometimes is not easy to take, but that's the truth.
I do think Mr. Peoples is entitled to some pretrial bail, if that, at this point.
So we'll make it academic, okay? Since he's on remand, and I agree, he is entitled to a reasonable bond. And a reasonable bond is certainly based on who he is, what he's shown before, capious history, and all of those things. So if you want a modification for bond, I'll be happy to do that. And we'll set the bond for $50,000, 10%. Because you're absolutely right. Everybody is entitled to a bond, especially on a case like this that is not a life offense. That absolutely is true.
Thank you, Your Honor.
Do you have anything else?
I do. Yes.
Okay, I'm listening.
So I did get this case because it was, I was House counsel on the 21st. I've been emailing with Mr. Lockbiller to try and get the discovery. And maybe Mr. Lockbiller can speak to this more if he was able to get the file, but I have not yet received discovery. At this point, I would ask that the court put a deadline on when complete discovery can be provided to me so that I can review that with him and start preparations.
Mr. Lockbiller, what was Mr. Peoples' offer to resolve this matter?
Offer on this case, Your Honor. Defendant was 19 at the time. I believe he'd be HIDA eligible.
HIDA eligible for B&Es, I think that might have changed a little. I don't know if if B&Es are part of the eligible crime group. I don't know exactly, but I'm just saying, I think.
Either way, there's no plea offered at this time.
What are his guidelines? Anybody know?
Oh,
I don't have a copy of the information even at this point.
Well, you have nothing.
Yes, that's part of the problem is it's been 30 days and I don't have anything other than the court record on Odyssey.
And you've emailed Mr. Lockbiller, correct?
Yes, we've
I do have a
emailed.
file now. I can get you the discovery as soon as possible. It's pretty thick file, so I'm not sure exactly how long it's going to take, but I'll put that request in today.
All right. So do you need anything more, Miss Elijah?
I would ask that all discovery be provided by the end of the month.
He just got the file. He said he's going to do it. If you don't get it within the next week, give me a holler, please, okay?
Okay, thank you.
You don't have to wait until next month.
Well, you should have it before then, but he had an attorney that had all the discovery at one point as well, so I will get it to you as soon as I can.
Anything else, Miss Elijah? Do you need me to explain anything to his people? And I'm not trying to make a pun on the last name Peoples, to Mr. Peoples' people.
Mr. Peoples, do you have any questions for the judge?
Yes, I do.
And how are you today, young man?
I'm doing fine, sir. How are you?
Well, you know, it's been a long day, but I'm clear thinking, I believe, still, and not feeling.
I just want you to know, Judge, see, the only thing we knew about this case, the family, that we saw a video of someone doing the B&E, and he wasn't in the video. And I don't know, maybe 10 days, 15 days later, we saw that on the news that they was looking for him. And once they was looking for him, I think they, he told us he didn't do anything. We didn't see him in the video. And the family, we kind of close knit. You can't find anyone in this family that has been, I'm 71 years old. I never had to go before a judge. My wife, she's 70. His great grandmother, she's sitting right here to my right. And his mom, she's sitting outside. We all worried. You know, it's no joke to us. You know, it's one of ours. And we kind of confused, what did he do? To be honest, we just didn't know.
Okay, well, all right.
And the only thing we found out was that a warrant was put out 5 days before he was arrested. And he wasn't in the film. Yes, sir.
Did you know that he had missed a trial date?
No, sir, we didn't. Because
did you know that he was coming to court?
In the beginning, yes.
And did
but,
you know?
But it was said, the only thing we knew, it could have been kept hid by who, I don't know, because I wasn't at the court. But we thought he wasn't in the video, and he told us he didn't do anything, and he wasn't there. And we played the video over and over, and we couldn't see him nowhere in there. We didn't see his.
Okay,
we saw the video.
But Mr.
So,
he had been arrested. He had been provided a lawyer. He had been going back and forth to court, waiting to go to trial.
Your Honor, 2 times I went to court with him, and we got there, nothing happened. It was one of these stalemate things that I didn't understand. We just didn't understand what was going on. And like I say, that's good you say you don't want to throw around the people's name. I hope you don't, because none of us here. I worked 38 years at GM. My wife worked 20. My daughter his mother is an RN nurse. His sister is an RN nurse. The whole family. My son, my oldest son, 53 years old. I've been married 53 years. So it's not like if we had a new, we hard on these kids,
Right. But it's apparent to me that that Deshaun intentionally didn't tell anybody.
We don't know why he's there. We still don't know to this day what crime did he commit, because we didn't see him in the video that was shown on TV.
Right. But he's been to court, and it's the job of judges and their lawyers and the prosecutor to tell the person what they're charged with. Miss Elijah knows, she tells all of her clients what they're charged with.
I'm quite sure he knew, but the times I went to court, it was it's like it is today. It was at a stalemate. Nothing was happening. And how much time can you spend up in court? Even though I am retired of 38 years, but I still have a life, you know.
No,
and
I understand, but everybody that leaves a court with the next date.
Hey, Judge, if you give him, I'll be on this case, not his mother, not nobody else. You leave him to me. We're almost identical. We're identical in looks, and just leave him to me. He can come right here and stay with me. You don't have to go to his sister.
Mr. Peoples, I need him to come on and tell me why he lied to everybody and made them think that the case was over.
You're right about that. I can't answer that. I don't know.
And if he's a 22-year-older, like I was a 22-year-older, there's a lot I didn't tell my people.
Well, I wasn't like that. If we ever raised to be like that, I would. Like I say, most of this family here, I mean, we ain't caused no problems. You know, I got my mom here. She's 91 years old. She walked 6 miles 2 days ago, and 2 days in a row. Today only 3 because of the weather. I mean, we just we're that type of family that you may think we are harboring somebody.
No, Mr. Peoples, I'm not thinking that at all. I'm thinking, I'm thinking that mamas don't know everything that their sons do.
You right.
Daddies don't know everything that their sons do.
Correct.
And there's a reason why they had that statement, what happens in Vegas stays in Vegas.
Yeah. You're correct. You're correct.
That's all I'm saying.
You're correct.
I don't know what my children are doing. I hope that they're acting all right.
But I got his mom here. I got his grandmom. I got my wife, and I got one of his sisters here, and the other ones are coming. I would just like to know, the question is, what did he do?
He is charged with breaking and entering.
But he wasn't on the video. That's why we kind of confused. He wasn't on the video. I saw the video. We recorded it and we played it over and over, and we couldn't see him nowhere on the video. You know, so we don't understand, you know.
You don't understand how people that are not guilty get charged with crimes. Come on, Mr. Peoples.
There was a video, sir. There was a video of the crime. It was a video of all the members who went into that school. The school is only a half a block from my house. I'm sitting right here in Romulus. We're in Romulus, Michigan. It was in Romulus, Michigan. That's where I am at the moment.
Mr. Peoples, did it have a video of the people that drove the stuff away, and the cars that they put it in?
No, I only saw the people who went in.
Okay, so I don't know if they're accusing your son of helping
grandson,
thank you, grandson, of moving the stolen property after it was taken from the school. He could have been that. I don't know. I don't know any of the facts.
Exactly. That's what we getting at. We don't know either.
But that's because he ain't told you.
Who told us?
He hasn't told you, and he hasn't let you talk to the lawyer to tell you what he's being accused of.
He told me in the beginning. He called me Papa. He said, "Papa, I ain't did nothing."
Okay.
And I said,
did he tell you? But did he tell you what they were accusing him of doing?
Yeah, the video. And I said, he said I wasn't with him. He said, I do know, the people who were charged.
I didn't ask, did he tell you what he did? I asked, did he tell you what they accused him of doing? What role they accused him of playing?
Well, he was accused at first when they ran his picture on TV of breaking into the school, but he wasn't in the video. So we was saying, well, why are they Why are they at him? We didn't really understand. Why are they at him?
And I believe the lawyer would have been able to explain to you. Do you know that you can get charged with a crime for being a lookout?
We didn't know he was a lookout. We
No,
we
no.
don't know any of that.
No. That's not what I'm saying, that he is. I'm not saying that your grandson was the lookout, but
Yeah.
you wouldn't expect to see a lookout in the video, would you?
No.
But people are lookouts. So I
But we
don't
would
know.
expect to know, was he a lookout? That's the question.
And that's why I ask you, did he tell you what they said his role was?
Right. No.
Did
We haven't heard. We haven't heard. No,
So you
sir, we
need-
haven't heard.
Okay, so you need to speak with the lawyer to find out what role they're saying your grandson played.
Okay. Can I get her a number? She can hear me, right?
Yes, she can.
Yeah.
I can hear you. Alanya has my phone number.
Okay,
I can
good.
give it- No.
Okay, I can get it from her.
Yeah.
And I guess I probably have to leave a message because if you like I am, you know what calls are coming in. Yeah.
I answer any call if I'm available and always listen to my voicemails. So I can call you back.
Okay, thank you, ma'am. Yeah. Any certain time I need to call when you're not busy or
Yeah, I can arrange that with Alanya.
okay. Thank you.
Thank you.
Mhm.
All right, Mr. Peoples, any more questions, sir?
We love him. That's all I can say. And I wish you, hey, if you want to come here and visit, hey, Judge, we want you to come here and visit and just see. This got to be the biggest misunderstanding. I may be wrong. Come out here and visit us and see what kind of people we are.
As soon as the case is over, you'll be my first stop.
Come out and enjoy and have a meal with us. I'm serious about that. Yeah, come out and enjoy.
And Mr. Peoples, I'm serious about accepting as soon as this case is over. I'll be the
I'm a
first
bike rider. If you like to bike, we can do that.
I'll be the first one to put my feet underneath that table.
All right, there you go. Thank you, sir.
Thank you.
Okay.
All right. Mr. Harris, we were scheduled for Micah Sharp sentencing today. When you were
Mr. Sharp is in your waiting room, Your Honor. I've called him and had him come.
No, he's not in my waiting room. He might be in Bruce Morrow Judge waiting room, but he ain't in docket C.
Yeah, he ain't in docket C, Ray. Oh, darn it.
And we just need a new date, Your Honor, for Mr. Peoples, and then we'll be done.
Okay. How are you liking September the 8th?
Great.
Okay.
Thank you.
Thank you, ma'am.
Thank you, Mr. Peoples. You can log off now.
Thank you, ma'am.
Hey, Judge Morrow, what happened to Raynard Sterling?
I have no idea what happened to Raynard Sterling. I haven't seen Raynard.
Mr. Sharp, I got you in the wrong room. Hold on, let me talk with the cuss. Just be quiet.
I don't think they brought him out of jail.
They got you on docket D now.
Okay, well, I'm gonna sign off, Judge.
All right, thank you, Mr.
All
Floyd.
right.
All right, peace.
Be on there now. Go back, clear that. Clear that.
Judge, I am sorry. I got Mr. Sharp in this room. Oh, got it. I apologize.
Don't worry about it. We needed somebody to hang with us after 5. We ain't worked this long since we was both 20.
I know. Oh, man. I got Mr. Sharp on the phone now. So I apologize.
Don't worry about it.
I should have told him.
Next action date on Peoples?
On Peoples, we said 9/8.
9/8.
Just hang in there, Mr. Sharp. Hold on for a second.
Figure, did you set a bond on Peoples?
No. Oh, yeah.
50,000,
50,000, 10%.
Okay. I lost that and all that talk. You said 9/8 for the next court meeting?
Yes.
Good. How-
Judge, do you want me to have Micah Sharp dial into your D docket or C docket, or how do you want to do this?
You can't zoom in?
Yeah, he can zoom in. I
Yeah,
can
he
give him.
he needs to zoom in because I got to give him directions. You know, he agreed to the first 90 days. He needs to turn himself in on on Monday.
He's got 167 days credit, Judge.
You're right. He sure does. Thank you, sir. I
Okay.
appreciate that.
Yeah.
Way to keep me on my toes.
Okay, then let me have him. I'll have him dial in, Your Honor. I'm going to just go sign up for a second.
Any idea how much longer this is gonna take? Because I mean, I'm supposed to be someplace at 5:30. And I'm obviously not making it.
Oh. Mr. Harris is getting in contact with Micah Sharp, and Micah Sharp is the last person. And as soon as we're finished with Mr. Sharp, we are all out of here.
Yeah, does me a lot of good right now.
Here he comes. Well, good afternoon, Mr. Sharp.
Okay.
Mr. Sharp, can you hear me?
Yes, sir, I can.
Okay, this is case number 21-0135. This is Micah Phillip Sharp. Your appearances this afternoon, please.
Good afternoon, Steve Lockbear for the people.
Good afternoon, Your Honor. Wyatt Harris, P54891, on behalf of Micah Sharp, who appears to Zoom with the court's permission.
With my permission, absolutely. Have you had a chance to review the pre-sentence report with Mr. Sharp for errors or for exclusions?
Yes, Your Honor, and we find the report is factually accurate and correct.
Okay. Mr. Lockbill, anything that you want to say?
I also had a chance to review the report. It seems accurate to me as well. We'd ask that you follow the sentence agreement in this matter.
Mr. Sharp, what do you have to say, sir? What would you like to happen today?
I would love to take the probation you guys have offered in the agreement and pray that you will allow me to credit for the 90 days for the time that I'd already served.
What else do you have to say about yourself?
Be very happy to put this behind me, and I don't know. I really wasn't prepared.
Mr. Sharp, have you stopped drinking?
Yes, sir. I've
Talk
been
to the
sober.
court about that.
Yes, sir. I been going to meetings and I've gotten all four of my children back together. Been paying my child support and been working with my brother and just been trying to stay strong.
So why so many mistakes so often, Mr. Sharp?
I feel like I've had warrants for a long time and it was always one or the other. And I was always running from one to try to be there for my kids. And I would always try to put them first when really what I should have done was put myself first and put myself in jail so I could put it behind me when I thought that I could take care of them, while I was running from the law, which was the wrong idea. And I've learned that now.
What did rehab, the Oakland County Rehabilitation, teach you?
That was when I was quite a bit younger, but
it was in 2016. Come on, man, give me a break. That was 5 years ago.
it helped me learn to take responsibility and that I needed to, and that it's going to be a lifelong, challenge for me to be able to stay sober.
And you didn't believe him, right?
Didn't believe him?
Mm-hmm.
Not at the time, I did not.
So why would you think they would lie to you, Mr. Sharp?
I've made a lot of wrong decisions and thought I was smarter than a lot of people in my life, and learning the hard way that that's not the case.
So you have to learn the hard way, huh?
The 6 months that I did in jail was the hardest thing that I've ever done. And
no, but that's not what I asked you. I asked you, so you one of those guys that got to learn the hard way.
It seemed like it's been that way for a long time.
Yeah, that's like them people that don't believe that vaccines work, and so their brother dies, and then they're like, dang, COVID is real.
Right. Well, when I was in jail, I was one of the only people who signed up to get the vaccine.
Why? You didn't want to die?
No, I did. Oh, no, sir. I do not want to die. Not yet.
Well, you think COVID's real?
I believe there's something out there that's killing people.
Well, some people would say it's alcohol.
And that's probably killing just as many people, if not more.
Right, but you seen them die, and you still wanted to not believe the people that this was a lifelong struggle.
Yes, sir.
I don't think jail woke you up.
It did, sir.
Okay. Well, let me put it this way. You might be right, Mr. Sharp. I don't think that experience can keep you awake. Does that sound silly?
It doesn't sound silly, but I'm taking it one day at a time, and I've stayed this strong since I've been out.
Well, you know why I think it doesn't work? Because so many people relapse.
Yes, sir. I've seen that many times.
Right. And so I don't think being aware that it will destroy your life will keep it from destroying your life.
I don't know. I mean, I'm aware, and I know that it will destroy my life. It has destroyed my life and put me in the situation that I am in right now. And since I have been out and been drinking, a lot of things have started looking up for me.
Some people think that a meeting every day is too much because they think that they don't need a meeting every day. They think once a month. Some think, once every 2 months, or all I have to do is remember. Now, sometimes the way to remember is to work it like you have the problem right now. Like if you don't go to that meeting, you're gonna drink. It's like taking this more serious than anything else. But the agreement was 2 years probation. You're being given credit for the 90 days you were supposed to serve. You're gonna continue with where are you doing your meetings or your rehab or?
There's like 5 or 6 different places that have meetings almost every day. I live in Livonia, but the main one I've been going to is a church over on 5 Mile between Merriman and so.
Okay, well, I'm gonna make at least 3 meetings mandatory every week. And if you do 5, like for 6 months in a row, we might think about early termination, but you're also gonna do parenting classes and you're gonna involve your children with the Alcohol Anonymous program for children so that they can understand what the addiction has done to you and how you need their support in fighting that addiction. They live in what, 3 different places, your children?
Yes, sir.
And how often do you see them?
I see my 2 oldest ones every weekend, and I see my youngest like every day or every other day, and my daughter every couple of days, the middle one.
Okay, well, you're going to have to involve some of your children's mother and ask them if they would be kind enough to help you help your children understand your addiction. Because there's family support for children and spouses and even for family members to help understand how to keep people with addictions as strong as humanly possible, because the stronger you are, the better father you'll be.
That's all I'm trying to do, sir.
So they need to be involved in your recovery plan. So you'll have to ask the women who are the mothers if they will be kind enough to help your children, to introduce your children to the program so that it can help you for your fight of sobriety. So that's the sense of the court. You don't have an absolute right to appeal your sentence and your conviction. You can't appeal by leave. Fill out the form that your lawyer is going to be provided within 21 days and return it, and we will provide a lawyer to help you perfect your appeal. Mr. Sharp, I expect it to be a bumpy road. Just make sure you keep going. Don't look for a smooth road.
No, nothing hard comes easy.
Yeah, but don't look for a smooth road. Expect a bumpy road so that you're not surprised. Be prepared for a bumpy road, and then embrace it. Say this is your life now, a bumpy road. Don't be pissed. It's just a bumpy road.
Hey, as long as I got my children in my life and I'm free, I'm a happy camper.
Yeah, well, you had all of that happening all along.
I did. I took it for granted.
So that's not going to make you happy. Mr. Sharp, you're going to make the difference. It ain't your children. It's not being free. This is your struggle for your life. This doesn't even involve them like that because they've always been there.
Right.
I mean, one's been there for 11 years. Come on, man. You can't make this about them.
Yeah.
This is you. So you got to own it and fix it. And fix it for you.
I'm going to do my best.
All right. I believe that you will. Just
I
stay strong. And like I said, man, it's going to be rocky. So just do it.
I'm going to do my best. I promise you that.
All right. I know you will, man. Good luck. The number I need you to call is 313.
313.
Yep. 456.
456.
4600. And you'll probably have to call them on Monday and let them know that you need to be assigned a probation officer, okay?
Yes, sir.
All right, man. Good luck again. Thank you.
I have one question,
Sure.
Judge. What do I do about my tether?
Oh, they're going to just go and take it off. I mean, go back to where it came from on Monday. I guess it's closed now, and they'll take the tether off.
I don't need any paperwork. They'll have it on file or whatever.
We'll send them something. Absolutely.
All right. Thank you very much, Judge. I appreciate everything you've done for me.
No problem, Mr. Sharp. Good luck.
Thank you, sir.
Mr. Harris, Mr. Lockbiller, Miss Smith. It's been a long, winding road today.
You folks have a good weekend.
Thank you. You do the same.
Okay, Judge.
Smith, if I was a drinker, I'd go have me a drink after today, but I ain't a drinker. So, and look at Mr. Sharp. Mr. Sharp said, well, I am. No, Mr. Sharp, no. Go have an apple, a piece of fruit.
Mr. Briscoe, can I get his case number again, please?
Who's? I can't hear you.
Briscoe. Oh, sorry about that. Briscoe.
Am I good, Judge?
Yeah.
Okay.
You're dismissed. Thank you, Mr. Sharp.
All right. Have a good weekend.
Martell Briscoe, 1965-96.
Thank you.
All right. I think we did it.
Yes.
We set a record. Longest I've been online. I'm about to go. How about you?
I'm about to go take a nap.
All right then, love. Thank you for your help.
You're welcome. Have a good one.
You too. Bye-bye.